appealing the matter of Coupang Corp and DAZN Group Ltd.
Mr. John.
My lords, I appear for the appellants together with Mr. Bruno and Mr. Morrison and Mr. Mohandas appear for the respondent. Can I just check your lordships have all the bundles in the requisite format and all documents you require?
So far as I know, we've got everything we need, and indeed we've looked at things pretty carefully, including the WhatsApp messages.
I'm grateful for the invitation, my lord. The structure of my oral submissions will then be as follows. They'll be split into 6 sections. First of all, I will say something very short by way of introduction and point to the most relevant parts of case law for this appeal. Secondly, I will look at the issue of offer. Thirdly, acceptance. Then I will consider the context, those 2 issues in light of the wider context, so the WhatsApps largely, before and after, looking at the position as a matter of substance. Then I will go on at number 5 to look at intention to create legal relations. Largely that's the order because the judge relied heavily on the background for that issue. And lastly, I will take rather shortly the injunction, the need for the injunction and the scope. So by way of introduction, this is a short question for your lordships on this appeal about whether an exchange of emails between the parties objectively, whether by that exchange of emails the parties objectively intended to and did enter into a binding contract. There is agreement between my learned friend and I as to the case law, the principles at least in the main. They're usefully summarised by Lord Clark in RTS Limited and Morelli, Allo, Muller, GmbH and Co. KG. That's 2010, 1 Weekly Law Reports, 753 at 771. For your lordship's notes, that's paragraph 45 onwards. It's in the authorities, tab 13, page 264 to 266. There is no dispute about them, but if your lordships would like me to take you to them, I will be grateful. In this case, the judge below found that the parties intended to enter into a long-form agreement at a later stage, but nevertheless there was a binding contract by the exchange of emails. That, in a nutshell, was his ruling, his findings. Therefore, in my submission, the most relevant case law, and obviously each of these contract formation cases is obviously fact-sensitive. I don't intend to draw any analogy with the facts, and that would be a waste of your lordship's time. But the most relevant case law is the Smith SMIT Salvage BV and others against Luster Maritime SA and another. It's the Ever Given case. 2024-2 All England Law Reports Commercial 504, a decision from last year of this court given by Lord Justice Males concerning the ship that got stuck in the Suez Canal.
And is that something you want us to look at or not?
Well, it is actually. It's the very last authority in the bundle at tab 19, my lords. Again, as I say, the details of that case are very different. But the decision, the summary I rely on, if you're at tab 19, starts at page 393 of this bundle numbering. I do apologise, I do mean 383, yes, that's the law.
Yes.
And really it's just the highlighted paragraphs, in other words, of the paragraphs 19 and 20 in particular, although before there's a reference to the case law he's seeking to summarise. And the reason I say it's the most helpful is that it's possible for parties to conclude a binding contract even though it's understood or agreed that a formal document will follow, which may include terms which have not yet been agreed. But whether this is what the parties intend to do must be determined by an objective appraisal of their words and conduct, and that the burden lies on the party asserting that such a contract has been concluded to establish that it has. And then there's the reference to the well-known formula of subject to contract. It doesn't matter if they're not used, and obviously it all depends on the context. And then I did, thank you Lord, mean to go to 393, just in terms of looking at the court's approach, not for the factors that Lord Justice Males lists directly above it, but for the approach, because what he says at 71, and what I repeat is true for this case, is that the burden is on the owners, in this case the respondent, who assert that there is a concluded contract, to demonstrate that the parties' exchanges evince unequivocally an intention to be bound. In my judgment and in agreement with the judge, they fall considerably short of doing so, for the reasons above, At the very least, those exchanges, is the bit I rely on, are consistent with the absence of an intention to be legally bound until all outstanding matters are agreed, which is not good enough for the owner's purposes. So, my lord, what we're looking for here, what your lordships are looking for here, are words and conduct which demonstrate an unequivocal intention to be bound.
Just while we're on this authority, could we have your comment on paragraph 74?
Oh yes, my lord, I'm coming on to that.
Standard of review.
Yes, my lord, I just want to finish the submission. That's my very next one, because I was going to say, while we're here, it's helpful to look at that, because my learned friends raised the issue of the approach of the appellate court. But I'm grateful. What the court is looking for here are words or conduct which demonstrate an unequivocal intention to be bound. What is not good enough is words or conduct which are equally consistent with the absence of such an intention. That is the touchstone of the exercise as we go through looking at the facts. And as I pointed out, SMIT is useful for another purpose as regards the approach of this court. As in this case, as he points out at 74, Lord Justice Mayles, Mr. Jonathan Gazeman, in that case, raised the question of the nature of the review of the appellate court in a case like this. And Lord Justice Mayles found at 74 that it was unnecessary to decide that because he actually agreed with the judge. But in any event, the issue doesn't depend on oral evidence, but on analysis of the parties' written exchanges and an exercise which this court is as well placed as the judge to undertake. I say the same applies here. In short form, my lords, I think my learned friend relies on the case of Walter Lillian Glynn, which was Lady Justice Carr, but even she says at paragraph 87, the degree to which the appellate restraint should be exercised, taken over needed, depends on the case, effectively. And is this court, did the trial judge have any form of advantage this court doesn't have?
DATEC doesn't, it says CF DATEC, and DATEC doesn't say that even where the appellate court is as well placed as the lower court, that it doesn't give deference to evaluative assessments from primary findings of fact.
No, I was going to rely on Lord Mance in DATEC, saying the appellate court is well placed and entitled to reconsider for itself the judge's findings.
You still have to show the judge was wrong, don't you?
Oh, I absolutely agree, my lord. There's no question about that.
We start with the proposition that he's made a finding fact, albeit based on written materials.
Absolutely. I accept to have to show that he has erred, otherwise I won't convince you that you shouldn't just follow him, for example. But the point that Lady Justice Carr made in Walter Lilly...
Should we turn that up?
Yes, please. It's at tab 18. I think it's bundle 374. But in fact, if you start at 373, you can see the beginning of that. I didn't need to see it particularly. But you can see at 82, she's saying that two grounds of that appeal involved challenges against the judge, finding of fact or evaluative facts. And then she goes on, my learned friend quotes that the courts have been warned repeatedly.
Sorry, where are you reading
I'm
from?
sorry, I'm reading from paragraph 82 and 83, where she starts there.
Yes.
And she sets out that the reasons for that approach, the restraint at the appellate level, is many. And they include the expertise of a trial judge, that the trial is not a dress rehearsal, duplication, have regard to the whole sea of evidence presented to him, whereas the appellate court may be island hopping. She says, well, but I would say may. The atmosphere of court can't be reconstructed, etc. In practice, you can't do it. But I rely, when one goes over the page, to what she says in paragraph 87.
You need to look at 86 first.
Yes.
Evaluation of the facts.
Quite.
Matter of degree upon which different judges can legitimately differ.
Quite. The appeal court does not carry out a balancing task afresh, but must ask whether the decision of the judge was wrong by reason of some identifiable flaw in the trial judge's treatment of the question. I entirely accept that, but that's a gap in the logic, a lack of consistency, or a failure to take into account some material factor. Indeed, one is supposed to identify those in your grounds of appeal, so it's burned into the nature of an appeal, which undermines the cogency of whatever conclusions the judge has reached. And I rely, in this case, on 87, in addition. The degree to which appellate restraint should be exercised in an individual case may be influenced by the nature of the conclusion and the extent to which it depends upon the advantage possessed by the trial judge. whether from a thorough immersion in all the angles of the case, or from first-hand experience of the testing of the evidence, or because of particular relevant specialist expertise. And that's a reference back to the factors she listed over Leaf. Well, in this case, my submission is the trial judge possessed no advantages that this court does not have, and none have been identified by my learned friend as a matter of substance. There was no first-hand experience testing the evidence. There was no oral evidence, so it was submission based on documents testing the same as in this court. There was no question of immersion in all the angles of the case. The trial was listed for half a day. It in fact took a whole day, and this appeal is already listed for 1 day. So there's not a suggestion that they had, the lower court could bask in 3 days of looking at the evidence. That is not the case here. And there is no, in my submission, no relevant specialist expertise of considering a short exchange of emails to come to a decision as to what they mean, frankly. So on the question of the appellate approach, I'd say we are firmly in the same position as the ever given, as per Lord Justice Nails, that the issue doesn't depend on the oral evidence, but on the analysis.
So just to chase it down a moment longer, does 86 apply?
It does. It does. Well, in a sense, as I say, because it's baked into the nature of appeal, that I say the judge has fallen into error. But
Save that it goes a bit further, doesn't it? It says there that the appellate court must ask itself whether the decision of the judge was wrong by reason of some identifiable flaw in the treatment of the question, such as a gap in logic, a lack of consistency, or a failure to take account of a material factor. Now, do you say that you have to satisfy one of those tests or not?
well, if I do, it's at a very low level for the reasons I've already said. I'm not going to stand in front of you and make submissions not refer to His Honour Judge Pelling's judgment at all. I will point to you where I say there are omissions. So I will seek to satisfy the latter. Whether I formally need to do so, I say no, not to any great extent, because we are in the same position as this court was in the ever given. Of really, this is the same exercise, and if there is a scale, we're right at the very lower reaches of it there, in terms of exercising restraint. So in effect, I'm saying you're able to vote with.
But in the ever given, well, Justice Nails said, that we don't need to decide that question because we're agreeing with the judge.
I accept that.
He didn't say because we're as well placed as the judge would have been, then no question arises.
No, I accept that, and I'm not saying that there's any binding nature in any of what he said anyway, for the reasons I've already given. But he does rely on the fact that there's no oral evidence, and that's obviously one thing that classically marks out the first instance from the appellate court's ability, the ability to look at the witnesses, to consider them against the documents, and also, quite frankly, the time expended below, with sometimes with opening submissions, looking at a long time to look at the documents, and closing submissions, and to really get into every aspect of the case. So there is a spectrum for the appellate court to consider. And my submission is that we are in the lower reaches of that. The same time is being afforded, the same documents are being looked at. I don't know how much reading time your lordships have had, but I would estimate it is not much more or much less than the judge had below. And therefore there is nothing that marks it out in that substance. I do accept that Lady Justice Carr referred to the dress rehearsal, for example. So and the waste of time, I absolutely accept that. So I say that when what one's looking at in her judgment is a range, and I say we're at the lower end of the range there.
I understand that. Whilst we're just sorting out the framework, the way you've put it so far is it's just a question of looking at the emails. This was a preliminary issue, I think, wasn't it?
No, it was a. Well, you're right.
Was
It
it a
was
trial
trial of
preliminary
that.
issue?
So, yes,
Which
you're right.
I haven't seen, but presumably was there a contract? And so
That's right.
what are the appropriate
That's right.
consequences if there was? Each side put in witness statements. In the written skeletons before us, both sides, I think, point to what they describe as the unchallenged evidence of their own
I do have a submission about that, my lord.
witnesses. But the judge seems to have recorded in paragraph 1 that both sides were content to proceed before him on the basis that it all depended on looking at the written communications.
Yes, I in fact made a
Is
submission.
that right?
That's right. We were given the opportunity to decide if we wanted to cross-examine, and neither side availed themselves of that opportunity.
That's not quite the same
No,
thing.
no, and I'm just explaining. Then when we got to trial, when there was a, what happened is then the witnesses had given conflicting evidence that had not been tested. So, for example, both parties, witnesses sought to say something about market practice, and
I'm sorry, it's a simple question. Is the evidence of the witnesses in or out?
well, actually, I don't think it was ever actually formally called. And the judge does. I did notice the judge.
You don't need to call anybody if it's a witness statement. It's self-proven
The parties
unless
treated
the
it.
agreement is that it's not before the court.
The parties proceeded as if it had been put in the witness evidence.
Is that right? You were there, so you
I
you
was
can tell
there.
us.
Yes, I know.
But the way the judge addressed it in paragraph 1 is, although the claim to pass no witnesses were called by either party, with each party being content to advance their respective claims, I referenced the communications exchanged between the parties, prior to the date of exchange and the conduct of each after the exchange. And the way you've opened the appeal suggested to me that you at least were proceeding on the same basis in this court, that actually we look at the exchanges rather than the witness evidence.
I did notice he said that a little bit. I feel it is a question I should be able to answer, but and I should be able to answer it more easily than I'm doing. I agree, but the way it wasn't really an issue below. Witness statements were in the bundle.
Let's take
Reference
it
was
in
made to
stages.
them.
The judge had in his bundle the witness statements.
Correct.
Yes.
Correct.
So therefore, the witness statements were in evidence. Yes.
Correct.
But there was no agreement that the witness statements be excluded.
No, that's correct.
Right. So therefore, we arrive at the position that both sides' evidence are before the court unchallenged.
That's correct.
And
So
just to be
that was my understanding, and when I said we all proceeded as if they were in that was my short form submission of the
And just before we hear from Mr. Morrison, by way of context, you find the directions order at tab 1 in the supplemental file, don't you? And paragraphs 6 and 7 deal with witness statements.
Yes, exactly, and both parties, there was a system whereby we were to notify if we wanted to.
And to judge by the fact that Mr. Morrison has sat down, I assume that was what
Yes,
he was
well,
going to point out.
I just wanted to draw attention to that. My understanding.
7 stand as evidence in chief.
Yeah, exactly. So, my understanding, just so it's common ground, and I don't want Ms. John to speak and then me to proceed in a completely different premise, is that the evidence, as a result of this order, among other matters, it is in evidence. The witness statements are in evidence, to the extent that they are uncontradicted, and there's no concrete argument based on documents or otherwise with what the witnesses said, and then in certain respects he did. The key issue, which I think may be a dispute between us, may not matter, is on the specific question of market practice, where there is an argument that there's a conflict of evidence, in which case there would be no way to resolve that. That may turn on an analysis of exactly what the witnesses said, but I'll leave Ms. John.
Yes, I see.
I'm grateful to Mr. Warren. That is exactly right. And when I come to it, where the parties, where for example he's referred to unchallenged evidence, which really is about market practice, I make my submission where it bites, if I may. But I'm grateful.
So that's the sensitive area.
I don't think it is.
Or at any rate, that's the area where there might be some sensitivity.
Well, where there's a conflict and no
Yes.
one's tested either side, it's a bit of a nil-nil, and the judge had no reliable evidence to go on, and therefore didn't, in his judgment, I think correctly, and I submitted that neither party could in fact rely on there being established market practice. And I'll take you to the bit in the transcript, and as I understood, Mr. Sheehan below accepted that. So that's how the evidence appears below.
Sorry to have held you up.
No, not at all. In terms of the framing, that I think is, I hope at least, is it. Before I turn to the first ground appeal, I do want to make it clear that there is no dispute between the parties, that in deciding whether a contract has been concluded, one must look at the correspondence as a whole. And as I've said, I'll make my submissions on the correspondence as a whole. But the case that the appellant had pleaded against it was that an unequivocal offer to contract was made in the 27th of February email, and that offer to contract was unequivocally accepted by the appellant in the 3rd of March email. And I'm starting by looking at those emails i.e. what is said by the respondents to amount to a binding offer and acceptance. That is a question of interpretation, and I'm looking first to the documents that are said to give rise to that alleged contract, i.e. the plain meaning of those exchanges if they can be ascertained on the face. Then I will consider the contract formation taking into account the correspondence as a whole. In my submission, that's a perfectly ordinary approach to the question of contract formation or interpretation. In my submission, the wider correspondence doesn't actually provide much assistance, certainly not pre the alleged contract, but we don't on this side of the court ignore the wider correspondence, which is a
Maybe
theme.
this is a non-issue between the parties, but I'm a little puzzled because surely, of course, you've got to identify the offer and you have to identify the acceptance, but save in the rather unusual case where there's no prior communications between the parties, which is pretty unusual, you have to view those against the context of the prior communications, don't you?
You absolutely do.
So
So
equally, I don't understand it to be in dispute that where the issue is contract formation, you can and should look at the subsequent communications between the parties to decide whether the contract was formed or not.
yeah, I quite agree with you, my lord. The question I'm seeking to
what's
hone
the
in on.
issue then?
The issue is that my learned friend has said we've sought to ignore it and asked you to make this decision out of the context, and I'm
You
saying
say not.
I'm saying that's not correct, and I'm explaining the pattern, the order of my submissions, in case your lordships were concerned that I was taking that approach. Indeed, my learned friend goes so far as to say that in our permission to reveal skeleton, we offer no factual narrative at all. In effect, he says we're inviting the court to address the issue without that context. And in that respect, he goes too far. You don't need to turn it up, but paragraph 21 of our skeleton, we say the communications between the parties formed the key evidence at trial, and we provided a neutral summary by the chronological excerpts you find in the core bundle, which were added to by agreement minorly thereafter. The appellant was asking the court to read the full suite of the relevant messages, not to ignore them, and that approach avoids reliance on selective quotation in the guise of a neutral summary. So it was a shorthand in a short period of time to make sure you had the relevant material in front of you, and they're not very lengthy. We then plug those WhatsApps into our analysis and our skeleton argument, so we don't accept the criticisms levelled by Mr. Morrison in that regard. So, to crack on, ground one is offer. We say the judge erred in law in holding that the 27th of February email from Mr. Kim of Coupang constituted a contractual offer. He felt properly to apply the principle that a contractual offer must objectively demonstrate an immediate willingness to be bound, legally bound, upon acceptance.
You say he erred in law. Can you just help me on that? I mean, of course, I understand you said he was wrong to say it was an offer, but where's the legal error?
The legal error is that he didn't address the question of the primary submission we made, which is the question of immediate willingness to be bound, is what characterises, critically in my submission, characterises the nature of a legal, an offer that's legally binding. So, our principal submission was below, and indeed remains on appeal, that the express wording in that 27th of February email describing Coupang's proposal as capturing their intention and their eagerness to move on to the contractual phase objectively show a lack of willingness to be immediately bound, which the judge wrongly failed to consider at all or address.
Well,
Certainly.
is that really fair? I mean, it's sort of another way of expressing the subject to contract type point. I mean, they go together, and the judge obviously was well alive to that.
They do fold in, they do go hand in glove in this case, I entirely accept that, my lord. But what he did miss out, if you're asking me to identify a gap, and I'm seeking to do so, is the centrality with which we, the importance we give to the intentionality. The expression of intention, I intend to do something, is not normally an expression of a willingness to be immediately bound. I do this, I will. It's not the same thing, and that's the central thrust of our submission, is namely, rephrasing it, a party doesn't seek to be bound without more by an expression of their intention. And the example, it uses different words, so your lordship may think it's not entirely helpful example, but just by way of illustration, I suppose. The case of Gibson and Manchester County Council, 1979, One Weekly Law Reports, 294, House of Lords, a case which involved mortgages and the purchase of council flats. I don't, again, the facts don't matter, they were very, very different, but the words that the council used was maybe prepared to sell. And that was taken to be, Lord Diplock held it was quite impossible to construe those words as a contractual offer in what was
That's
quite
because may encompasses may not.
well, I entirely agree. An intention may change. An intention is not an offer which immediately says, all you need to do is write back to me, bang, we're finished. I intend to acquire this in the future. It's a very different form of wording and a critically different form of wording in my submission. And that was our primary argument below. And I entirely accept the judge did deal with the second part, moving on to the contractual phase. The equivocation, I mentioned both because they go hand in glove. They both equivocate what might otherwise be an offer. But the primary submission is that the lack of concentrating on the key words used. And I don't know if you all want me to turn up the emails so you can look at them while I'm making these submissions. They're right at the back of
So we're at 281, aren't we? At the back of the
right
supplemental.
at the back of the supplemental one.
Yep.
It's the contract in the time-honoured fashion.
And I mean, it's sort of the same thing. It's a question of, is this saying we're willing to be bound now, or are we anticipating that there's going to be some later putting things into a formal contract?
And that is essential. That is the central question, my lord. Absolutely. And what I say is that the more natural. I have two submissions. The more natural reading is mine, especially when you've got equivocal words, not words of clear words of offer. And the second point is, if it's equally capable of being read either way, Coupang cannot succeed.
Yeah.
Because on the Smith test.
Can I just ask you a slightly different question? In your submission, what is the relevance of any of the fact that these are non-native English speakers using English that is, shall we say, less than idiomatic?
No party adduced any evidence that there was anything about the parties, any of the parties' abilities to express themselves adequately in English, and it would be a very difficult move for this court to interpolate that into a very short exchange. I accept, my lord, that were there to be longer exchanges with some strangeness within them, you might have an indication on which you could say, well, perhaps that's just the fact that these were, well, I don't even know, in fact, if they're not non-native English speakers, as not been known to the court. So,
Excuse me,
Mr. Lee says he. I think Mr. Lee says he isn't.
Mr. Lee didn't write this email.
No, he gave it.
No, I agree, but I'm just looking at the email. I'm sorry, my lord.
we are dealing with a gentleman called Danny Kim, based in Seoul. You seriously suggesting he's a native English speaker?
I'm not, it's not a serious suggestion. I'm seriously suggesting there's no evidence one way or another. He could be a
On
US
the face
expat.
of the document, probability is that he's Korean. Yes?
My lord, that's what you want to read into it.
My lord, I don't want us to proceed in a false premise. Mr.
Fine.
As correctly pointed out by Lord Justice Popplewell, Mr. Lee says this point in his witness statement, says he's a non-native English speaker, though he's able to give evidence in English. Mr. Kim says exactly the same thing for paragraph 4 of his witness statement, page 17 of the...
I'm grateful. My learned Jews pointed me to the same thing. But what the key point there is they both said they have enough fluency to write witness statements for this court. And in those circumstances, I don't think there's anything in the point that in the short email exchange they can't perfectly clearly express themselves. And certainly, I would submit there is no legs in any such submission.
Well, I'm sorry, but let's be realistic, shall we? We now establish that he's not a native English speaker. And just to take a simple example, he says captures our intention for acquiring. Now, you say this is a statement of intention, and intentions can change. My question is, to what extent is it relevant in your submission that the semantic structure of the sentence does not accord with the English used by native English speakers?
Is your lordship suggesting that the more grammatically correct would be our intention to acquire?
Yes.
I note that. I would say that in quite a lot of the
You
emails
say that's
I read-
irrelevant?
No, I say it's irrelevant. I mean, I don't want to give evidence to Scott, but in quite a lot of emails I read from native English speakers, I wouldn't be surprised to find this formulation grammatically incorrect as it is in there. They're not barristers. I mean, even in barristers, my own communications are not without their grammatical flaws. So I would say when one is looking
I'm sure that's fair comment. But what in your submission is the relevance of that?
I say there is no relevance because capturing an intention is exactly what he's doing. They hope to acquire, and it's not saying we are sending you a formal offer, for example. I mean, it's what it doesn't say is not a very helpful way of testing what it does say, but you get cases with say contract confirmation, confirming our contractual offer, etc., etc. I don't criticise the salesman for not including those.
So one might paraphrase it as being, wants me to send the proposal by which we hope to acquire.
I would say that's a fair practice.
So one has to look at proposal as well as hope to acquire the interests.
I totally accept that, my lord.
And if proposal means offer, which was how it was referred to in the later correspondence, the fact that it's an offer by which someone hopes to acquire the subject matter of the contract doesn't stop it being an offer, does it?
Well, again, I would also point while we're here, just so that that the subject matter of the email is also refers to the rights proposal. You can see that at the bottom of page 280. Mr. Kim has marked it subject Speakable World Cup Media Rights Proposal. See that?
It's a proposal.
It's a proposal, but in sales terms, the way I characterise this, my lord, and it is impressionistic, is that what you have here, and we'll see this when we come to the background, is a sort of calling it a bidding war is going too far. But there are a number of bids coming in, and Coupang wants to be the preferred bidder. So here they are, they're putting out, here's what we hope to, here's our stall, here's what we hope to acquire, using your lordships. And at the same time as saying, here's what we hope to acquire, they say, so here's our headline figure, and here are the bare bones of all the headlines of the commercial deal that we hope to do. And then they say, we're excited to land this deal with you and eager to move forward to the contractual phase. Now that's read as a whole, impressionistically, which is an exercise in how it struck the judge below, and where I say he went wrong, is ignoring the fact that the two combination together, the intentionality of hoping to acquire and the moving into the contractual phase, shows that this is really them sticking their hand up saying, we want you to move forward with our bid.
This question, I'll try and make it my last question on this topic. Surely any offeror is expressing a hope that their offer will be accepted, because it may not be accepted.
Well, I would answer that by saying it could. That's true, that could be the case. But if you write, for example, here is our offer, we wait to hear back from you, we wait to hear back from you, please accept this offer, that is much stronger grounds to say that you're going to be immediately bound by it. Not, we hope to make you an offer, for example, which is another way you could read this. Our intention to acquire, we hope to make you an offer. So, in those circumstances, it's the two-pronged nature of it which you have to read together. And I'll come on to make my submissions about whether, and if so, how the factual background exists in this very short email. But you've got what we say is Coupang putting their hand up, saying, here's the broad, very broad, high level. Can we go forward and contract?
And is it irrelevant to your submission that Mr. Marr, in his reply, interpreted this as an offer which was capable of acceptance?
Well, now we're moving on to my ground two. But,
But this is on ground one, because you say this was not an offer capable of acceptance because it was a pure statement of intention. Whereas Mr. Marr's reaction in real time is, we will accept Coupang Play's offer. So he thought it was an offer and that he could accept it.
Well, I'll come on to whether an offer can radically turn into an offer by virtue of the acceptance that follows it. And I take
Of course he can't. Of course he can't. If it's not an offer capable of acceptance, then the fact that it's accepted doesn't transform it. But
that's my first answer to your lordship's question. But I will deal with that point, if I may, when I come on to acceptance, because again, the lines I'm drawing are artificial, as your lordships have already identified. We've got a short exchange between offer and acceptance, with subject to contract or intention, or all in the same time. So I'm attempting to tease out some lines of analysis. But I entirely accept that I have to address the point about Mr. Marr's response, absolutely, and I will do so under the heading of acceptance. As I was submitting, this was our primary argument below, and indeed, as we say, it's central to the basic question of whether it can be an offer or not. And what does that show an immediate willingness to be legally bound by the specified terms on acceptance, or is it more in the way of a salesman saying, here's our bid, please consider us, and then we'll move forward to the contract? That's literally the question for the court. And I say it's the latter. And I say even if it could reasonably be read as either, that's good enough for my purposes on this appeal. So, not to labour the point, we've already raised it, but the second point on this email is obviously addressing your lordship's point. I accept that the word proposal is used. In my submission, the word offer could have been used, and it wouldn't have made any difference. It's expressed as an intentionality. There's nothing magic about the word offer. The real question is, what is this email doing as a matter of substance? So proposal could be a synonym for offer. It might not be in the circumstances. And I say in the circumstances, it's a proposal to move to the contracting phase. That's how you read this. This is our proposal. We would like to contract, and this is how we'd like to contract with you. That's our proposal for the contracting phase. That's my submission. And they say they're eager to move on to that phase. Another point about that is that makes it clear they were not in the contractual phase. If you thought you were entering into a contract, it would be a very strange thing to do, to say, let's move on to the contractual phase. You'd be actually seeking to get a contract.
What do you say is meant by the contractual phase?
Well, I'm saying that, so my submission is that Coupang putting their hand up saying, here's the framework for our bid, we want to move on. There's no intention to be immediately bound, we want to move on to draft a contract and get it binding.
So it's the drafting process of the formal contract, is it? You
Yes.
say?
Yeah, it's setting out.
That equally is a point of time at which there isn't yet an agreement on your case.
Sorry, my lord.
Your point was it can't be been in the contractual
Yes,
phase because they haven't got a contract yet.
that's right.
That would be equally true if they meant by contractual phase the drafting of a long form agreement on your
This
case.
is the problem, my lord. Equally true isn't good enough for the respondents. I accept it might be capable of bearing both of those meanings, but if it could reasonably bear both of those meanings, they have to show an unequivocal intention to be immediately bound. A central thread of my submissions is if this email is capable of being read both ways, that doesn't assist them. So I accept that that's possible. They could say, here, it would be a very strange thing to do, to say, here's our offer by which we want to have an immediately binding contract, and in the same breath say, we'll move on to the contractual phase. Because what if they're making an offer, that is by its definition the or a contractual phase.
Well, I suppose a possibility is that they might have had in mind, well, when you accept, we'll be in the contractual phase. I mean, we're eager to move on to you accepting so that there's a contract.
They might mean that, and here one does get a little bit of assistance in my submission from Mr. Marr's email response as to what the parties mean by that, and that is relevant. It could bear any one of those three meanings, my lord, and again, as I say, if on a reasonable reading, it could bear any three of those. That doesn't assist.
That's not good enough.
In my submission, there was a gap here with the judge because he didn't explain why it was preferable in this instance to interpret the words moving on to the contractual phase to positively mean that parties would be moving to execute, really strictly speaking, a second contract in addition to the one that the judge found had just been was being offered. The reality is, in my submission, the judge never really said in clear terms what he thought that phrase meant. And if you look at 17, around paragraph, I didn't turn it up because it's not there, but around 17, the judgment, he doesn't really engage with what's meant by that phrase in the context and how one reads the email as a whole, which is what one should be doing.
Because when he refers to it, he refers at the same time to the terms of the acceptance.
Exactly, my lord.
Makes his comments out.
Sorry, do you see there is a gap if one is identifying one there? I'll come back to this point and look at context, but it may be helpful for your lordship to know, or not, for me to flag this now, which is that there is nothing in the WhatsApp background communications that indicates that the parties were intending to enter into a binding long-form agreement, a binding agreement first, and then a long-form agreement. This isn't the sort of case where you'll see them saying, well, of course, we'll sort that out later, or no need to decide that. We don't have that kind of assistance from the WhatsApps in the background. As I say, our position is that the claimant, Coupang in this case, wanted to be the preferred bidder, so it set out its intentions for price, etc., the basic parameters, and then wanted to move forward to the binding contract. I can see that I'm just repeating myself if I say that. So, my lord, if you look at the plain words of the email, I say that it is either there's no evidential basis, there's no words or conduct from which it can be objectively ascertained that they wanted to enter into an immediate binding contract by this email. It's all forward-looking, even accepting the somewhat semantic point. It is all forward-looking, it captures an intention, and it, in the same breath, envisages that there will be a contractual phase, and that is either because they don't want to be immediately bound, or it's equally capable of being read that way.
What do you say about the words, we're very excited to land this new deal with you? That's not, obviously didn't mean we think we've got a binding contract by this proposal, but was that not a wish that, when they said we look forward to hearing back from you soon,
Yeah.
that would involve landing the deal?
Well, again, this may depend on what landing the deal means, because on my submission, what they're doing is attempting to get preferred bidder status. That's what this means. So they're basically saying, move forward with us. It's a long process to get a binding contract, but move forward with us, and we're excited to.
Where did the word preferred bidder status come anywhere in this email?
Well, nowhere at all. Obviously, my lord. That's my
How do you get
submission.
that out of this? Which words do you rely upon as conveying that meaning?
Well, I don't, my lord. And as I said, I get them when we come to the WhatsApps. I'll show you what was actually going on in the background. What Mr. Radrazani, on behalf of DAZN, was talking to Mr. Lee about, and why I say that you get this different bids, preferred bidder status, and wanting to move forward to get that. So that's how I say. And also, again, sales will always talk about landing deals. That doesn't mean that that's what this email is doing. It means if you're getting progress and moving forward, that's what I say that refers to. It isn't the language of binding contractual. It's puffery of a salesman saying, we want this, we're really keen, want to move on. Not much weight can be attached to it in my submission. Well, a short point, which is, I think your lordship's already adverted to, which is that in the judgment, the judge moved straight on to the question of agreement before looking at, he applies effectively in my submission the wrong legal test, but perhaps the better submission is it just doesn't really address the right legal test. He skips ahead in his judgment, and we say he doesn't properly identify the context or evidence in which it can be ascertained that this party intended to offer and be immediately bound by that offer. He doesn't point to any, and in my submission the respondents don't point to any. The respondents appear to rely in their skeleton argument at paragraph 51.3. Your lordship are using the bundle version, but that's tab 6, page 71. On Mr. Pork's evidence that in relation to the Club World Cup, DAZN is willing to make outline agreements before entering into full long-form agreements. That is a partial summary of Mr. Polk's evidence. Mr. Polk made that point in explaining that the ordinary practice was for long agreements to be entered into, but that the initial outline agreements, the heads of terms that appear in the bundles, were negotiated, lengthy, involved documents, signed heads of terms agreements. There's nothing in his evidence that suggests that DAZN was willing to enter a contract by much less formal means. So that's our point I think it's a point that helps your lordship, but it's not a point my learned friend can rely on. That's my submission. And here we come to the uncontested evidence of Mr. Lee, which your lordship raised, as regards industry practice, and that's in my learned friend skeleton in a number of places, 2.2, 6, 12 and 51, and you'll probably find it in mine, although I've sought in my oral submissions not to rely on any such point. The respondent's skeleton paragraph 51, for example, relies on Mr. Lee's evidence, saying that it's typical in the sports media rights industry for parties to switch from informal channels of communication such as WhatsApps to email when they wish to formalise an agreement. Well, that's what Mr. Lee said, but Mr. Polk, with his equally uncontested evidence, says at paragraph 13, for your lordship's note, that's in the supplemental bundle, page 24 to 25, he says, I note that Mr. Marr refers to preparing a draft contract for review, talking about the acceptance email, it's said to be the acceptance email. This accords with my understanding there is no binding agreement, so a contract's been prepared, negotiated, agreed and signed. This is best practice across the industry because the detail in sports rights broadcasting agreements is so crucial. Deals have to be signed off by DAZN management before formal contracts are signed, etc., etc. So you've got a, insofar as it's acceptable for witnesses to give, reported to give expert evidence, you've got a clash of evidence and no cross-examination. So the position was explicitly set out at paragraphs 15 and 16 of my skeleton argument at trial. Just you'll note that's in the supplemental bundle at page 148, where I explain that.
I'm sorry, we're the trouble is all these points blend into each other,
They do.
and we may really be more on subject to contract here. But if one goes back to the earlier parts of Mr. Phelps' witness,
Oh yes.
Mr. Parrott's witness, it really starts at relevant. It starts at paragraph 7.
Yes.
I'm on page 22 of the bundle, saying sub-licensing in this case was unusual because there was only 6 months and we usually have
Yes.
18 months. Then paragraph 8 describes what is actually going on. And paragraph 9 seems to move to the general practice. Once a decision has been taken to proceed with a particular bid, we prepare draft heads of terms documents, which form the basis of a further negotiation to agree binding HOTs.
Yeah.
In the context of most rights sales, our process is to proceed straight to preparing a draft long-form contractual agreement. However, for CWC, we took the approach of first agreeing binding HOTs before moving on to a long-form contract.
Yes.
So, in terms of their practice, whether one describes it as market practice or not, it seems to accept that their practice was to have a stage at which there were binding terms before the formal contract was signed.
Yes. Sorry.
Is that a fair
That is absolutely fair. I perhaps took my submissions
summary
to.
of his evidence, and that doesn't sit particularly happily with paragraph 13 saying it's always necessary to have the formal contract prepared, negotiated, agreed and signed because it needs sign off by management, unless by that he means assigned heads of terms.
Yes, no, I think the difference there is between talking about what generally happens and what was happening with a more compressed 6-month timescale in this Club World Cup. But what, I don't know if your lordship has ever had a look at.
Sorry, can we go back to paragraph 9 because he gives the rationale. He says the use of HOTs therefore allows us to reach binding deals which cover essential terms but remain subject to the agreement of a long-form contract.
Well, yes, well, I don't think there's any part of my case that I don't accept that's a possibility for any contracting parties to do, enter into a binding agreement and then seek to negotiate. That's the only question is whether that's what these parties have done here with these emails. And if one refers to the heads of terms themselves, you'll see that they are extremely lengthy. Might it be helpful to turn one up now just by they are in the exhibit to Mr. Polk's statement, which we'll find in tab 5. There are 3 different versions. if you go to page 48 of the bundle, this is another point my own friend refers to: extensive negotiations having taken place. A characterisation which I take issue with, because when one looks at what these legally binding heads of terms, whether they're in the draft or the signed, this is a signed version, in fact, redacted, you can see it's set out in quite a lot more detail. A number of points. You've got the long form agreement is set out there. I absolutely accept, my lord, that is what is envisaged, and that's not an unusual commercial practice. Over the page in 49, for example, the event, the licence of acts of territory, the rights period. Rights period I don't think is specified in the email. Permitted languages certainly isn't. Permitted transmission method certainly isn't. Permitted services isn't. The types of rights set out isn't. Media rights, clips rights, ancillary rights, promotional rights. None of these are made clear or explicit, or the detail is notably absent. Access not set out. Minimum broadcast obligations not set out. We will come back to look at exclusivity, but one can see that there is quite a lengthy section on exclusivity, and if you're there, you might mark up the second paragraph, which I rely on, particularly when we come to look at the injunction as to what exclusivity means, co-exclusivity means between these parties, none of which is obvious from or included in the short form email, informal email that your lordships are looking at in the present case. Over the page, sub-licensing, again not set out with any detail. Reserved rights not dealt with. License fee not dealt with. Ad sales, I'm flicking through obviously. Page 53 not dealt with. Delivery not dealt with. I mean, none of these points is really of a totally different species to what Mr. Falk's evidence is about. And that's relevant to the commercial background, the factual matrix that you're looking at, which is it's inherently improbable that the more complicated we're not selling a loaf of bread. I think that's a submission I made below. Here, do you want to buy this loaf of bread? It costs £1.50. Yes, I do, thank you very much. The more complicated the deal that's on the table, the less likely parties are to have intended to be immediately bound by them. And this heads of terms, there are three different, and their terms do vary. So they are negotiated, heavily negotiated in some cases, are demonstration, evidence before the court of what is involved with coming into a preliminary agreement that the parties intend to be binding. So if, taking your lordship's point, or taking mine, this is our broad outline, we want to move forward to the contractual phase. This is phase one of that contractual phase, this binding heads of terms agreement. We want to start populating this document with you. That's what that means. What could equally mean we want to go straight to, in other cases, straight to the long form agreement. But it is inherently implausible that these parties, knowing, no one suggested that anyone was an ingenue, if I pronounce that word correctly, to media licensing. They both knew it was going to be this complicated. So the question you have to ask yourself, with that factual background in the matrix, is it really plausible that 5 bullet points, they intended to be legally bound into a deal with 5 bullet points? In my submission, it weighs again against the likelihood of the parties intending to be immediately bound. So that's what I say about Mr. Polk's evidence and the documents before the court supporting it. The police now moving on to ground 2, no unqualified acceptance. Again, sorry to make the submission to this court, but it is uncontested basically the principle that acceptance for contract formation purposes is a final and unqualified expression of assent, whether by words or conduct, to the terms of an offer. You can't, an email which purports to be an acceptance, if there's not been an offer, an email that purports to be an acceptance can't make a contract.
Yeah, if you failed on ground 1, there's an offer. Of course, if you succeed on ground 1, all of this is academic anyway.
I quite agree, but I have to make that stage 1 submission, my lord.
So
We only hear.
how does ground 2 help you independently of grounds 1 and 3? Assume you lose on ground 1, assume you lose on ground 3. Can you prevail on ground 2 on its own?
Well, Now, I'll approach that gently, if I may, because again, one is looking at all together, but I say I can.
The question was the real point here, because it's already been put to you a number of times. The real point is your ground 3. And what I'm trying to test out is whether you're serious in submitting to this court that you can win on ground 2 on its own, in the face of an email which on its face uses the word offer and accept in pretty unequivocal terms. And of course, you know, if there's no offer to be accepted upon a proper analysis, it gets them nowhere. But does ground 2 on its own really have legs?
Well, of course you're right, I'm looking at my submissions and they mainly go to the subject to contract point. And the way I was going to do it was make those points, and when I got to subject to contract, say, well, I've already made these points. You're quite right. The only point I'll essay or sally forth with in isolation on this point is this idea that the use of those words, and I use it in different contexts, but the use by a salesman, not a lawyer, of the words offer and acceptance imports anything particularly important. Again, you know, if my M&A lawyer sends an offer and says offer, that means one thing. If Mr. Ma from wherever he is in Korea sends an email saying, thanks for your offer, it could mean lots of different things. He's a salesman, not a lawyer. They're talking about a proposal that
In my respect, he doesn't say thanks for your offer. That would indeed be equivocal. But he says, I'm pleased to inform you we will accept Coupang's offer. We will start contract drafting. Now, of course, the we will start contract drafting supports your ground 3. So, but
I agree. I would accept, my lord, I think, apart from the short point that I've made, that the use of the words has to be read in the full context and isn't necessarily as talismanic as it would be if it was exchanging more detailed quotation quotes, for example. But beyond that, I accept that the majority of my submissions go to the subject contract point, because we say it's a qualification on the assent. So in a sense, there are those words perform two functions. They qualify the assent, and they are in any event subject to contract. So those are the majority of my submissions. So I'll make those. It may be, I'll make those as shortly as I can, and I'm going to look at the background. I kept subject to contract for after the trot through the background, because the judge really referred to those majorly in his judgment, and it wouldn't be very helpful to keep popping in and out of the WhatsApp, so I intend to deal with them all in one go. But I apologise if there's therefore any repetition. I'll keep it to a minimum. So your lordship's quite right. We absolutely rely. We don't ignore the first sentence, but equally you can't ignore the second one. And we say it is a qualification on that acceptance. In the same breath as accepting, you're referring to the drafting of an agreement and sharing that draft for your review. So you might agree or disagree with it, for example. Cannot be said to be an immediate and unqualified acceptance, and equally we say it's a clear indication to the contrary. Start contract drafting. There is a point here which one might think is asking too much, the short email, which is that for the judge and the respondent to be right, you'd have to read this very short email in my submission as follows. You read the first sentence and go, fine, oh fine, that creates an immediately binding agreement. Agreement 1. Then we take the second sentence to mean immediately the parties intend to enter into a second agreement. That is the logical breakdown of the approach the judge took and the respondent's case. And that in my submission is an implausible reading of this very short email. It cannot bear that interpretation. And again, you're not going to be surprised to hear me saying that at the very least, my meaning is equally capable of being born, and that's not good enough for Coupang. One final point, because my genius reminded me of it, just one more effort on the acceptance alone point is that looking at the question of whether a contract was actually formed, whether these parties intended to be bound in the moment by doing this, the point about the use of the words offer and acceptance could be as not being by themselves enough, is again raised in Gibson and Manchester County Council, where I'll give you the note, but I don't think it's worth turning it up, is it? Authorities Bundle tab 346. An internal memorandum from the town clerk, presumably not a trained contract lawyer, recorded that Mr. Gibson accepted the council's offer, but before the papers could be passed to me for preparation for local elections, and then they no longer proceeded with the mortgage or the right to buy. So again, the fact that those words appear either in the documents themselves or in the relevant admissible background to the construction of what the parties meant isn't by itself sufficient to cross the line in my submission. Otherwise, I'm going to move on to, I don't know whether, I don't have the live note in front of me. I don't know how upset the transcribers, the speed I'm going at one.
I'm afraid in this court, absent special pleading, we don't normally break for
That's all I was checking.
transcribers.
I'll bear that in mind and attempt to go slower for the transcribers' benefit. Now we're at point 3 of the structure of my submissions, which is to look at the wider exchanges between these parties and what the parties did before and after to set whether that helps setting the emails in their context. I make 3 overarching submissions of points to note as we go through the communications, and helpful indication you've read them, my lord, so I won't.
Yep.
Obviously, you must ask whatever you need to ask me, but I won't take too long in doing it. First is that the central evidence is in the WhatsApps. There were telephone calls between these parties, and we'll see those. You may have noticed yourselves on reading that there are these null entries. I don't know if you noticed that. As I understand it, the null entries are either attempts to call or actual calls.
So these are WhatsApp calls?
I believe so.
Yes, I see.
It's sometimes possible to ascertain. For example, you get an entry that says null message. I tried to call you. Well, we
Yes,
can
I see.
ascertain that they didn't speak then, but it's not always easy to tell when they have not spoken. There were telephone calls, but there is no evidence beyond very general evidence from Mr. Lee as to what was said in those telephone calls. His evidence, you'll notice, we've already looked at paragraph 19, supplemental bundle tab 2, page 8, and I'll come back to that, but he doesn't give any detail, particular detail, as to how long these were, how many they were, what they said, what was actually in any detail. There's no evidence at all from Mr. Radrasani, and just to make a submission about that, the claimants in their particular claim did not plead that anything of import took place in the initial negotiations, whether by telephone conversation or WhatsApp or otherwise. There was no pleading that any prior or subsequent communication had any import in their case. The claimant's case is now, it's been developing since Mr. Lee's evidence, that there was an agreement in principle that was reached in those oral negotiations as between Mr. Lee and Mr. Radrasani. That was not pleaded, and it's only in Mr. Lee's evidence. Mr. Radrasani didn't send the 2 emails that were identified, didn't send either of those emails, so there is no evidence from him. The evidence, therefore, in the main, is centred on what can be ascertained from the WhatsApp evidence. Second point to bear in mind as we go through is, I think it's fair to say it's more my characterisation, so I'll be fair about that. It's my characterisation of what you're about to read, which is that there were a number of interested parties, and you'll notice there were bids coming into DAZN for the right to broadcast the FIFA Club World Cup in South Korea from parties such as NAVA, SOUP and Coupang. Those are 3 that are named. Mr. Radrasani and Mr. Lee had a personal and a business relationship, that's in Mr. Lee's evidence, and they were both pushing for Coupang to be, at the risk of innovating, my lord, the preferred bidder. Absolutely my spin, that's what I'm saying. What the WhatsApp show is that Coupang, with Mr. Radrasani's assistance from the inside, had in the course of conversations ascertained what the appropriate parameters would be for what they hoped would be an attractive, I say, agreement in principle. In order to reach that agreement in principle with DAZN, that agreement in principle had to be put to DAZN not simply discussed with Mr. Radrazani, and you can see that clearly from the WhatsApps. That's why we say the 27th of February email is sent from Coupang. Notably, there are no references, I've said in the prior WhatsApps, to a written agreement following or anything useful like that. This is not a case where the evidence shows that the parties, there's nothing objectively ascertainable to say, oh yes, they were obviously trying to be bound, and then move on to do a contract as well. What the evidence, I say, shows is that Mr. Radrazani, at least initially, successfully pushed and got the green light for Coupang to move forward into the contractual phase. There was an agreement in principle which expressly refers to moving on to that contractual phase, and that's what we say these WhatsApps will show. Thirdly, as I've said, my learned friend characterises these WhatsApps, must be the WhatsApps in the main, I accept there were telephone calls alongside, but we don't have any evidence, safe evidence as to the extent of that, as extensive. He says it in both paragraph 2.1 and 45 of his skeleton. Indeed, at 45 of his skeleton, his submission is that the email exchange that I've just taken your lordships to was the culmination of extensive negotiations on WhatsApps and in oral conversations. And I don't agree with that characterisation. I've already taken your lordships through the heads of terms, which might show what extensive negotiations, at least even the initial ones, might look like. But the reference to oral conversations in my submission may go slightly beyond the evidence that my learned friend has. I'll just make that point. But we'll go on to look at the WhatsApps. So let's do that. They're in the supplemental bundle. I think it's better to look at them, subject to your lordships, in their native format, if that's the right expression. A supplemental bundle, page 86. Now, I will try. There are three types, or three threads of WhatsApps. They're behind tab 8, we've got Mr. Lee and Mr. Radrazani. Behind tab 9, we've got Mr. Lee and Mr. Ma. And behind tab 10, we've got Mr. Kim and Mr. Ma. And I will try and keep it chronological because I think it's more useful for your lordships. There'll be a little bit of flipping between the three tabs. But
There were one or two references in the chronology that's in the bundle to communication between Mr. Radrazani and Mr. Ma, that is to say internal. I don't think we've got those in our bundles, have we? But can we assume that if they're in that chronology, they're agreed? I don't think they're particularly significant.
No, we don't have them. And equally, my lord, I'll come to it. There are things where Mr. Lee says he's receiving internal communications about the deal, as he puts it, and we don't have those either. So we don't have any other communications between internal communications. But
So we don't have them. I mean, they weren't in evidence.
No.
Because they are included in the chronology, I think. But maybe that's.
Can I just?
My lord, I think some care needs to be taken with this. There were other internal documents, including some that are very arguably significant. Some of them are exerted. We took the view, given the injunction not to put excessive factual material for the court of appeal, and I'd like to take you to some of the detail, that we didn't need to put those in as well. They were disclosed, they were referred to at trial, and the passages in the trial transcript, so they do exist.
I'm being corrected by both sides, and they're quite right to do so. I think there's reference in the chronology. They were available in the trial bundles below, but they're not reproduced in a native format.
So, Ms. Morrison, can we take it that the references to them in the chronology are accurate?
They are accurate as a subset of the full material. There isn't a lot more, but there is some more. There's one point so far, I'll consider about this before I speak, where I may need to say a little more on that to potentially correct a submission that's been made, but I'll see if that's necessary.
Thank you.
I look forward to that. Right, so those are the three.
And can I just, we've got times on those things. Are all the times in the same time zone?
I'm afraid I've asked that question as well, my lord. I don't know. I don't know. I think Mr. Radrazani is in a different time zone.
Well, the people may be in different time zones.
Exactly.
Can I, as I understand it, Mr. Lee is in Singapore.
I believe that's correct.
Mr. Kim is in Seoul, which is an hour's difference, I think.
Yep, that's right.
And were Mr. Ma and Mr. Radrazani in London?
Well,
I got the impression that Mr. Radrazani was, because he's saying, I'm going to go to bed now, when the conversations are getting towards the early AM times.
Contrary to what you said, these are not native format, these are extracts from WhatsApp. I don't know, I would hazard a guess that the time zones represented are based on the time zone of person carrying out the extraction.
That would be my, and I'm sorry, I did say native format if that's the right term to use, and I'm perfectly willing to accept it wasn't, but I will make some inquiries and we can work out which time zone we're in for each of them, so we can be clear about that one.
And time zone on the emails that we've been looking at, because I've done my best to try and put those into sequence.
I will get some instructions to fix that for you over lunch break.
The point of what I was suggesting, if it's correct and I don't know, is that the times shown on that hypothesis would all be internally consistent, but they wouldn't represent the actuality as experienced by the participants at the time.
I believe that's correct, that's my understanding as well. I'm not sure, and again, I'll probably be correct on all sides, I'm not sure that this is a case where anything particularly matters on terms of like whether it was sent before or after, whether it was 20 minutes. There are some occasions that may be more interest to your lordships, the precise timing. I'm not certainly particularly turns on it, but for good order, I will take instructions on the time setting in each of these clutches of WhatsApps. So, the respondent says the negotiations began in February. It's probably more accurate to say nothing really happened if you're on page 86 with me on Mr. Lee and Mr. Rajrazani. But nothing really happened until the end of February. One can see, if you're looking at the hard copy just below the hole punch, there may have been a call on the 22nd. We don't know too much about that. Then on the 30th, Mr. Rajrazani provides some information, and he says, this is the general rules have been confirmed overnight with FIFA.
Sorry, just before we get there,
Yes.
we've moved to the 30th. On the 22nd at 5:14, Mr. Rajrazani sends a file, SIBA, DAZN World Cup, file attached. Was that the master license agreement?
No, that's not the master. I understand that's
what
a
is
PowerPoint.
that?
It's a PowerPoint presentation that was in the evidence below, which was contained lots of lovely pictures of footballers and some information, but not very much information about the licensing process. As I understand, it's not in dispute between us that the head license agreement has never been provided to Coupang.
So, for the avoidance of doubt, it's a PowerPoint presentation in PDF format.
Yes. I'm told it's a slide deck in PDF format. So it might be in PowerPoint. And then he says,
there's a reason why you do that. It takes up less data. When you compress it into PDF, it's a smaller file. So you start off with a PowerPoint, you turn it into PDF, and it's less of a clog on the WhatsApp system or the email, as the case may be.
in fact, if I read more carefully, I would entirely agree because it says .pdf on the actual line.
Thank you.
So, thank you, Lord. So, obviously he sends that, and then there appears to be, potentially been a conversation following it, but we don't have very much detail about that. Then Mr. Rajrazani says about a week, just over a week later, John, that's Mr. Lee's first name, this is the general rules have been confirmed last night with FIFA. Please let me know if it's acceptable with your latest offer.
Well, that's presumably referring to the .opus. Now, that's not one I'm familiar with.
That we on the sub-report think that that's a voice note, but it wasn't available to us. We haven't heard it. It wasn't in evidence as far as I'm aware.
Well, it says it's a file attached.
Yeah. Again, I'll make inquiries, but that was the base on which I proceeded below, and I
And
haven't.
when he says this is the general rules, it sounds like he's referring to a document being that attachment.
I do agree with that, unless what he's saying below is this is the general rules, my lord. Because you can see below he sets out some.
And then it starts, the feed will include. What does that mean?
So this is when you get the live feed, what it's going to look like.
Oh, I
at the
see.
other end
Yes, I see.
in
Yes, I
the-
see.
So it's going to have a sponsored clock
Yes,
and
I see.
clear graphic.
Yep.
So I'd rather read it, my lord, as the general rules of what he's saying below.
Yes, I see.
But I can't, because I haven't seen that attached file, I can't say that it is, I can't say that in certainty.
Yeah.
It is worth bearing in mind that the head license, as I understand it, the long form head license wasn't agreed at this point. It wasn't agreed between Coupang and DAZN and FIFA until about the 8th of March. May, I'm told. But anyway, so he says considering 50% of the gains. So at that point, they're thinking about giving Coupang 50% of the gains, and they're setting out some very basic initial information about what the feed will look like. That's
Sorry, end of May. The master license between FIFA and DAZN only agreed at the end of May.
the long form version of that was agreed on the 8th of May, I'm told.
8th of May, sorry.
Yes, that's. And as I understand it, it isn't provided to sub-license ease as a matter of course. It's not provided. So then Mr. Radrazani is setting out the basic as starting the logic of the feed and then some of the sponsor requirements.
So when Mr. Lee says on the 30th of January the sponsorship guideline seems to be fine, presumably again this is a reference to the .opus file.
No, I think it's when you see about. Sorry, I can't answer that absolutely. But my interpretation of this is if you look just above, just right at the bottom, page 86, you can see the sponsored man of the match overlay. Second, presenting
This is all about
sponsors.
what's appearing in the feed.
That's true, but you can see what this is the sponsorship requirements for the feed. So I think you can have a clean or a dirty feed, or you can have a feed with stuff in it. And he's saying this is what the sponsors want to do 4 times during the feed game at half time before the second half. All must be carried by every sub-license. And then there's a reference to what inventory can be made available.
Does that mean what the sub-licensees will themselves be able to include in their feed?
Yes, exactly.
So if you look at the third line, the fourth line, no association can be created between advertising stroke sponsors and FIFA, the tournament and participating clubs.
Yeah.
It recognises that the sub-licensee will be able to insert its own advertising and or sponsorship parameters into its broadcast, but subject to those restrictions.
Yes, and that's a sort of high level. Here's the parameters of what you may or may not do. I'll just answer a question about the Opus file. My learned junior, and I use that underlined, tells me that Opus is definitely a voice note and that he knows that. I asked him how he knows that from the documents we've received throughout the trial. So if there's any disagreement about that, I'm sure we can iron that out. So sorry, my lord. Yes, as you were saying, it's sort of setting, if you like, sort of basic ground rules for what the licensees will and won't be able to do thereafter. And Mr. Lee says the sponsorship guidelines, one assumes in response to that, seems to be fine. But then he says, are you saying we can only broadcast 50% of the event? Are we going to be able to select the games that we want to broadcast? And Mr. Redline says, no, you can broadcast all the games if the offer is good enough. And then Mr. Lee says, so you're suggesting 50% if we keep our offer the same that we propose to FIFA. We can skip down. Mr. Radrazani says, about halfway down the page at 6:37 p.m, what was the FIFA offer, question mark. And then John Lee says, I can't remember exactly, but I think it's around US dollars, 330,000, I'll double check. Radrazani says, for this, I think he means budget, don't know. For this budget, I don't think we sub-license at all, but I discuss internally. So he's basically saying that's no good. Then they talk about potentially, Lee says, I can probably do a little bit more, but nothing dramatic. I think a total of 3 bids in Korea, and our offer was the highest back then. So what you've got here is Mr. Lee's already been in the bidding war, already trying to get these licenses directly from FIFA. They haven't gone down that road. And he's saying, how much do I need to offer, basically? And he's saying there were 3 other bids. Then the next thing, and apologies if your lordships just trying to skip a little bit, but at 8:09 p.m. in the bottom 8th of the page, 6th of the page, you've got Mr. Radrazani. Our expectation is over 2 million. Mr. Radrazani is telling his friend what he thinks DAZN want. And Mr. Lee says, I'll try and give you my best offer. And he's expressing surprise, 2 million in Korea. And then he's saying, in Japan, we've got 3 for 1 cycle. Mr. Lee's asking him, and he says, yes. Mr. Lee at top over the page 88, can't do 2 million, that's too much. And Mr. Radrazani is saying, we got an offer. So this is a horse trading price conversation. It's too much. Mr. Lee continues at 8:12. Mr. Radrazani says, I understand. We asked 3 mil to Nava. That is Coupang's big rival, as I understand it. They will not pay 3 million. I know. Spot TV might be interested. So this is where I'm coming to with the preferred bidder status. You've got various number of people trying to bid for these rights, as I say, throw their hat into the ring. But then you see halfway between the punch holes at 8:15 p.m, Mr. Lee saying, non-exclusive is not an option that we nor anybody would prefer. So he doesn't want it to be co-exclusive, is what he's saying there, in my submission. Then he says, a bit later on, I'll come back in a few days when I've discussed internally, explored the options. Okay, thanks. I'll try to get max budget as well, says Mr. Lee. To clarify one thing, we cannot coexist with Nava because they are a free platform. Please keep this in mind. Thanks. Sure. And then that's all right at the end of January. So they've been given very basic ground rules. Then they've had an initial discussion about what sort of price might be attractive to DAZN in a context where there are bids. That's as far as we get there. Then nothing really happens until a week later on the 6th. Sorry, there is a null at 5, I should record, but I don't know what import that has. Then there's it comes after Mr. Lee's informed we can't consider anything less than 1.5 million as we've already had something at that level. So this is where in my spin, you've got a sort of bidding war, preferred bidder, trying to make yourself the most attractive bid situation. And what you see here is Mr. Radrazani and Mr. Lee together trying to work out if they can make Coupang the most attractive bidder. Over the page into 89, there are a couple of nulls that's talking are available. And at the top of the page, now 20th of February 2025. So this is a week before the email comes in. Now, nothing that's happened so far in my submission could really sensibly be described as negotiations other than as a horse trade over price. Not on these WhatsApps. There's a bit of basic information about the feed and the sponsorship ground rules. But these are not extensive negotiations culminating in a letter that's intended to be binding. They are two friends trying to work out what price they need to put forward. And here we are a week before the so-called offer email comes in, and there's nothing like extensive. There's almost nothing like negotiations at this point. So we're now in a 1-week period, and what Mr. Lee is still saying, there's not been very much progress, because on the 20th of February at 5:16, Mr. Lee is saying, Andrea, that's Mr. Radrazani, I spoke with the CEO, and he's asking whether exclusivity is not possible at all. Can you speak with FIFA and try to carve out Korea? We want to do the deal with you guys, but free broadcast on DAZN will damage our business too much. So they don't want co-exclusive, because they know that DAZN put out free broadcasts. That's what this says. And Mr. Radrazani is saying not possible, unfortunately. So it's co-exclusive with us free broadcasting. Can you please ask, at least try, I did, they said, impossible, question mark. Then I think, my lord, there's 2 more voice notes, which we don't have. 3, sorry. Can't hear, whatever, null. Mr. Radrazani says, John, let me know, I would like to make it work. Let me know in the next few days.
Sorry, just before we get there. Not possible, unfortunately, that's to say, exclusivity. Can you please ask, at least try, I did, they said impossible. That refers to asking FIFA, does it?
I believe it does, my lord. I don't know, I'm trying to do my best to... Oh, sorry, I think what it means is, do you, DAZN, really want to be co-exclusive with us, or are you happy just let us do it in South Korea?
That makes sense. I thought I'd seen somewhere that was a reference to asking FIFA. Which
I think there's an earlier
didn't
reference to FIFA.
but not this one.
I-
All right, that's
Doing my best to assist on the reading of the short form WhatsApps, that's what I think that means. Because he says, can you at least try?
so that's interesting.
I believe that's the. Yeah. Basically, Mr. Rajazani is saying a bit later that day, I'd like to make it work. Let me know in the next few days if you're interested to make an offer. Me too, I will provide an offer, don't worry. Please accept it though, haha. Mr. Rajazani smiley face. Would it be much easier if we had exclusivity? And then there's a discussion about the Saudi league, which I think, if you go down to the last entry at 457, and it says we haven't secured the rights there, I understand that's all reference to the irrelevant reference to the Saudi. Then they have a conversation. So now we're 2 days before. Nothing's. What my learned friend discussed is a culmination of extensive negotiations. There's very little, no evidence for these WhatsApps. Then he says, you can see at 5:12, Mr. Redrazani says, 5 entries up from the bottom, I was going to call you as we do have an offer. And I don't know what GAD means to us. From another player, 2-0. Here's the page. I call you okay. We don't know necessarily what they said. Confidential. I've interpreted that to mean he can't say who the other bidder is, but I don't know. Thanks, Andrea. Then he says, please find out the minimum amount that we need to pay to secure the rights. Thank you. And Mr. Rajazani says 1.7, I push to get you the rights. He means push internally at DAZN. So this is hardly an arm's length commercial negotiation. It's a conversation between people who have a close business and personal relationship trying to get Coupang to win this bidding war.
Just to be clear, what do you take from that?
What
I mean,
take
on
is-
the face of it, you have the representatives of the 2 potential contracting parties, who evidently were on friendly terms. But absent some complaint about Mr. Radrazani's authority, why does it matter that they were on friendly terms?
Well, this is what I'll say later. It's the picture I'm building up when you get to the end of it, is that what they're doing, 2 things. First of all, it's clear from these WhatsApps that Mr. Radrazani and Mr. Lee did not have an agreement in principle on the phone, because what Mr. Radrazani needed to do is to go off and ask internally in DAZN. So the respondent's case on that is simply not made out on documents. Because if they had an agreement in principle, why would he need to ask? He keeps saying, I'll go and make it work, I'll push for you. So that's one of the things, that's why, one of the reasons why it matters. Another reason why it matters is when you look at what goes wrong, they want this deal, these 2 individuals want this deal to work, and they feel aggrieved when it doesn't. And I say that is important to how you read it. Plus, it's not really a negotiation, is my point. It's not an arm's length negotiation.
But why does it matter? You say it's not an arm's length negotiation because the representatives of the 2 contracting parties are friendly with each other. I mean, you're not suggesting that Mr. Radrazani was acting in breach of his duties, so who cares?
Well, it's partly because when one looks commonly in the background, one sees a submission that, when one reads the case law in this area, that there have in fact been extensive negotiations where discussions have been had about certain terms, draft terms have been drawn up, things have been set out in longer form, and so there's been a lot of work done, and then you come to the moment of the point where you want.
Sorry, you haven't answered my lord's question. His question is, what is the import of the word not arm's length, which you used more than once? What does that mean, and what is its legal significance?
I'm endeavouring to answer it. I'm not. I'll retract it to the extent I don't mean to suggest there's anything important about the fact that it's not arm's length.
So we can strike the words not arm's length.
Yes, I think you probably should. But what I'm trying to build the picture of is this is not a case where you've got 2 arm's length counterparties negotiating for a long period of time on the detail and coming to the moment where they want to get something binding and saying, here we are, here's the detail following extensive negotiations. My own friend has characterised these emails as the culmination of extensive negotiations, and I'm saying they are not that. And I agree, let's strike the other words from the record. At 1.7, I push to get you the rights. I need to talk to Warren tonight or tomorrow morning, but I will convince him. So again, this is not, they're going internally into zone. Mr. Rajasani not really able to make any kind of agreement with Mr. Lee. Okay, thank you. I'll speak to Stephen, make final decision, etc. Stephen must be internal to Coupang. And then Mr. Rajasani says, I gave you all the info, really appreciate it, brother. I'll do my best, but never is crazy, etc. So 2 days before, nothing really happens. Then on the 27th, the day of the email, there's obviously a call, potentially a call around 7ish, null. I can't find your email. I believe it's Mr. Lee's evidence that they had a conversation. Mr. Rajasani asked him to put it down in writing and send him an email, and that does appear to tally with this record. Can you give me your email? There's a couple. Sorry, thank you for everything, etc., etc. Then they talk about, I think that's Major League Baseball in Korea. Right. Then the chronology goes on to the bottom of page 90.
So at 7:51, he's saying sorry and thank you for everything. Great to do a deal with you. That suggests that the conversation has involved by that stage the offer of 1.7 million. Is that the reasonable inference?
Well, what I say that shows, my lord, and thank you for bringing to my attention, is that these guys are using the word deal in a very loose way. That great to do a deal with you. He knows, as I think what's that will show, that it needs to go somewhere else. There is no deal done at that point. So they're using it broadly to mean the proposition. Because this is the 27th of February, all they've
Yes,
done.
and it's the same language as Mr. Lee uses in the email he dictates to Mr. Flynn. Make the offer short.
But he's saying, great to do a deal with you.
Yep.
They haven't done a deal. So these are salesmen hoping that they're going to get a deal done and using words. Yeah.
It's the same point as arises out of the terms of the email itself.
Yeah, sorry, it dovetails with the wording of the email, I agree. Then at the bottom of the page, 8:22 p.m, Mr. Rajasani, John, I have an internal call tomorrow morning. I think my recollection is that my checking was that the 27th is a Thursday to discuss. Please confirm, please understand there is someone who wants to push the other deal, through the other deal, sorry. I'll call you as soon as I can to confirm. So this is why I sort of characterised it as a sort of bidding war with various parties throwing their hat into the ring.
Well, I think a message between Ma and Lee comes in between those.
You're quite right. You're quite right.
8:12 on page 104. Ma says, "Hey John, just got the update from Andrea on his conversation with you. Plus.
Yep.
So again, that suggests that they've had a conversation in which the offer is being communicated.
It does, my lord, and again, at this stage, it's just what my own friend is characterising as the offer letter, but it's them sitting down and writing. And the point is that they've been pushing Coupang to up the offer from the 330,000 up to something more palatable. Mr. Rajasani has said 1.7. I'll push the deal through, and you can see that Mr. Lee is saying in that conversation with Mr. Marr on page 104 at 8:14, much more than we expected, but all is good. I know that you guys are giving out some money as well. Really appreciate it. The deal's still not done. It's still.
Well, they've been led to expect that if they come in at 1.7, Mr. Rajasani would have squared Mr. Palk, and that would be acceptable as a.
Well, but he'll push it through. Is what. Yeah. That's I say is the most they can be led to expect at that point. To the management level decision. At that point. And Mr. Lee is saying here. Because as my learned June is pointing out, if you flick back to page 91, at 90, Mr. Rajasani is saying, I have an internal call tomorrow to discuss and confirm. Please understand there's someone who wants to push the other deal through. I'll call as soon as I can. And Mr. Lee says, you can do this, Andrea, haha. So they know that there is a bidding war going on here, and it's not in Mr. Rajasani's gift to bless the deal, as it were. As I say, they're still talking, as some salesmen do, in terms of like, great, it's not my solution at this point, even though we're still in the foothills, my solution, the very early foothills here of the bidding war, and trying to get a number that DAZN will even be interested in. So, keeping on page 91, if that's where your lordships are, 28th, Mr. Lee is asking if everything's good, he wants an update. And Mr. Rajani is saying he's got a call soon, and about half an hour or so.
This is now after the email's been sent.
Correct.
That's
Yeah,
the
it's the next
email
day.
comes next, and then we move on.
Exactly. And the next day, Mr. Rajani is saying, all good, John. We need to wait till Monday, because I think 28th is a Friday of February. We need to wait till Monday for an official feedback in order to inform properly the other clients who made offers to our Japanese office. Warren and myself clearly expressed our preference to work with you. Thank you, Andrea, really appreciate it. We are receiving another offer today from Soup, but we've cleared we intend to work with you.
What do you say is meant by official feedback?
Well, I say that's the management decision to move forward, to say there's enough money in this for us to be interested in contracting with you, so let's move forward and contract with you.
To inform properly the other clients who made offers.
Yeah, we're moving
So
forward.
official feedback. We can't. It means the others have to be told they're not in.
We're
They're not
moving forward.
in the game.
We're moving forward with a Coupang bid. That's what I say that means. Yeah. You've got to make a decision who you're going to. It's not a short process. These contracts going into these contracts, drafting these sets of terms.
There are two quite separate concepts. One is we're going to go forward with you, but we're still willing to take offers from other people, and until we've done the deal with you, you haven't got the final contract. The other is we're going to give you official feedback, which will mean we stand down everybody else in your favour. And what Mr. Radrazani seems to be suggesting at 427 is that it's the latter. So
Well, we'll see. We'll see whether Mr. Redmond is correct in his interpretation of that, my lord, in a bit, because as soon as very, very soon after another offer comes in, offers are coming in all the time. So whatever happens, offers don't stop coming in during this timeline.
We've seen what happened even
Right.
after
But we'll see.
the 3rd of March. But we're just looking at, as we go along, what
Yes.
the background is to. We've now had the what's said to be the offer email, and this is now looking at the period between the Friday and the Monday.
Yes. And
So what Coupang are expecting is official feedback.
that's right. Yeah.
Thank you.
I think we do absolutely accept on the basis of this evidence that Mr. Radrazani, Mr. Lee and Mr. Radrazani knew that Mr. Radrazani could not bless this, even agreement in principle, we would say, and that he needed to go to management. There are a number of bids coming in for a decision to be taken. Now, it's the character.
The point I'm putting to you
I do
is
understand.
that
I do understand.
they were led to understand that if and when they were given that feedback, that would be official in the sense of they would have exclusivity. In other words, they'd got the contract to the exclusion of.
Oh, sorry, I was thrown by exclusivity. Co-exclusive with DAZN,
No,
but with the
sorry.
other bids,
They'd got
going.
the contract to the exclusion of being able to keep other
Of course
people.
not, I wouldn't agree with you.
Litigation.
They've got the contract. I would say that we're moving forward with the Coupang bid over, for example, the Naval one.
I know you say that, but if official feedback means feedback which means that the other clients will be informed that they are no longer in the game.
Or that we've got a better offer, my lord. That's that we're going with this offer, and that my submission is what happens, because you can see that in a matter of days, having been told that, immediately another offer is made. Nobody walks away going, "Oh shucks, the official feedback is that we can't continue to up our offer." The evidence is that everybody continues to up their offers, and I'll take your lordships to that. So I'm not sure one can read too much into what Mr. Radrazani's own personal view is.
Is that right? I mean, we see from the entry of 428 that NAB is offering 2.5 million. So
Yeah.
it's not that there aren't higher offers elsewhere. The official feedback will be whether we're going to take your offer to exclude other clients.
Or tell everybody else that we're moving forward with Coupang, which is how I would characterise it.
Why would that be of interest to other potential bidders unless they were being told we're not going to move forward with you?
Well, if I was bidding and someone told me we're moving forward with Coupang, I might say, well, I'll add another million. Does it matter if I add another million in? And then the answer might be yes, it might be no.
Thank you.
So you're quite right. The final bit of that was relevant in that day is that Mr. Radrazani is telling Mr. Lee what the NABA offer on the table is at that point in time, 2.5 million, including 500,000 of ads. And then what you have just above the punch hole is the 3rd of March, so that's the date of the email. Again, this is where perhaps where the timing matters potentially more important. Mr. Radrazani, it's unclear whether Mr. Radrazani sends this before or after.
So sorry, I was just making a note. Where are you now? Which entry?
I'm just at the move forward to the 3rd of March.
401.
401, yeah. The time again.
Again, have we got a? We've got a MAR to Lee communication.
We do. I'll come
on
to
the
that.
20th. Well, shouldn't we look at that in sequence?
Oh, it's 20th. I'm so sorry. Yes, ma'am.
on the 28th at 5:45, I think. Let me see if I could noted that correctly.
You do, my lord.
28th, 5:45. Mar says, just want to say what a week it's been. Great outcome to secure FIBA with Coupang and now FCWC.
Yeah.
Whatever interpretation one puts on it, Mr. Marr thinks that FCWC is secured. Is that fair?
Well,
With
that's certainly the thing.
Coupang?
What? So FIFA, just so your lordship's aware, is the zone set of basketball.
Yes, that's right.
But you're right.
And now FC World Cup is
Yeah.
what we're
I mean,
focusing.
obviously, what this gentleman is saying about securing isn't even right on the facts, because an offer has come in. Everyone's waiting for the official feedback. The NABA offer on the table is higher, so nothing has been secured at this point, and even on the basic technology. And so, in my submission, these are people with personal relationships exchanging what they are hoping is the case, what they want to be the case, not what actually is happening. And that's why you've got reference to securing the deal. And if that's so, in my submission on the 28th, to say we've now got FCW secured is the opposite of what Mr. Radrazani is saying, which is there's someone else who wants to push the other deal through on the 27th. He said, I can do it. It's waiting till Monday. So really, the question is how much assistance can be provided from what salesmen are saying to each other in WhatsApps and hoping is the case, willing to be the case in my submission. So going back to, and there is a, I think Mr. Lee, Mr. Marr, just so you're aware of it, coming up as well, but Mr. Lee, Mr. Kim on the 3rd. But sticking first with page 91, we've got Mr. Radrazani saying, John, good afternoon, deal is confirmed. I'll follow up with Charles to coordinate the draft agreement. So in my submission, you pretty much have almost exactly what is said in the email.
That's, again, if my knowledge is right, possibly before that, there's an internal exchange between Radrazani and Charles and Marr,
Yes.
technology, in which Radrazani tells Marr that he's had an email from Shimon, so we can proceed with Coupang.
Yep.
And Marr says, yes, we can proceed with Coupang. Would you like me to respond to John's email? Radrazani says, yes, we can confirm and give instructions to the legal team for to draft agreement.
That's right, my lord. And both that internal
That probably
communication.
before the 401 entry we now.
It's I think it does, my lord, and just to be trying to be explicit on the chronology, the timestamp on the Mar email of the 3rd is 4:16 p.m. But again, we don't know where he is or how exactly that fits in with these timestamp on these.
It seems to fit in pretty well with
It does.
the
I agree.
timings.
I don't know if there's anything
No.
particularly. Yeah.
Because you then see at 1:08. Well, I suppose it's an hour out actually. 5:16. Mr. Marr saying just sent you an email. So maybe there is an hour's difference.
Maybe it is the Singapore stamp we've got on the emails, and on this one, at least on Mr. Kim and Mr. Mars, it could be a
Yes.
They just haven't been added.
It isn't. We will iron it out. I'm not sure it matters because the point I'll make about those exchanges is this: it's exactly what's in the email. It doesn't help. It doesn't say anything more. It doesn't say anything less. In my submission. So there really is no assistance in that. In the same breath as saying you're confirming it, you're saying you're going to follow up.
But it looks as though the exchange we've got at 91, at 401,
Yep.
deal is confirmed after Charles to coordinate, is before the email is sent.
It could be on that timestamp. I agree, Mel. And I'm not sure.
And that fits pretty well.
It does.
Yeah.
And equally to the response at 5:05.
And then this is the point I was making, my lord, perhaps not too heavy weight of, but in the next day, the very next day, we've got Mr. Vajrayani saying we've received a higher offer. So the point I was making is whatever's happening on the other side of the fence, if you like, the feedback's been given, we're proceeding to I would say, proceeding to enter into a contract with Coupang. Someone else comes in and says, well, hold on, I'm going to add an extra 1 million to that deal. At least that's what Mr. Vajrayani is saying. And Mr. Lee says, what, from who? And then Mr. Vajrayani says, I'm working internally to stay committed in what agreed, but the deal was finalised, Andrea. I don't know what TT means. Same guys, come on, I know, it's what I said, don't trust their offer, it doesn't make sense. So, and then at the bottom, leave it with me, they may have had a phone call, doesn't look like they did, based on the times. Bro, please help me out, it'll be a disaster if things go wrong. I promise I will help you to zone out in the future, and to be honest, don't trust their offer, it doesn't make sense at all. Well, look, you might say, I mean, he did say, to be fair, the deal was finalised, but he's still considering that they could contemplate the higher offer. And that really is saying he knows he doesn't have a concluded contract. He thought they were moving forward with him. He thought he'd got management sign off on that. He feels gazumped. This is my submission about what he's saying.
Hang on. So he knows he hasn't got a concluded contract.
This shows, sorry, this is what I'm saying, is objectively when you're trying to look at this, what would someone do if they were gazumped, effectively? Or do they,
His very first response is to say deal finalised.
I accept that, absolutely. He said,
It's only then he adds, and don't trust them anyway. I mean, why is that undermining his first response?
I totally accept it does say the deal was finalised, in the same way they've been saying the deal was finalised on the 27th, 28th, before it was in fact finalised. So the question is, what does this really mean? What are these guys really talking about?
Well, surely it's perfectly understandable. Number one, you've got to deal with me. Number two, don't speak to these other guys. Why is number two inconsistent with number one?
Well, it's not necessarily, I will entirely accept that as a reading of these WhatsApps. What I'm saying is that what it also could be is that you've had an agreement, you've effectively a gentleman's agreement that they're going to move forward with you. You've gone to the extent of having internal sign-off on that. Fine, it's got to wait for the ink to be dried, but you feel like you've got the deal in commercial terms, and you feel annoyed by it and aggrieved, and it's perfectly understandable that people get annoyed when people walk away from so-called gentlemen's agreements in commercial terms. It happens every day. You thought the deal was done. It wasn't.
And can I just try to understand what tests we're applying here? On the claimant's case, the contract has been concluded, but the authorities show that it's possible to take into account subsequent conduct.
Yes.
Now, you say that shows he didn't think a deal was concluded. That's subjective.
Correct.
If we're worried about subjective understanding, then we go to his witness statement, presumably, to see what he says he understood.
I don't think we're not looking. We're looking for what their words show, objectively ascertained, what the parties intended by the. That's what we're looking for. The problem I think with this particular case is that when one looks in other cases at subsequent conduct, you're looking at other things. For example, the Derv case, you're looking at the fact that they in fact kept the container to harbour the gas, or whatever the right term is, free. They took substantive steps on the understanding there was a contract. That's one example. Or you performed the contract, for example, in RTS. The contract was performed and 70% paid for. And all of that was relevant to whether there was a contract. What you've got in my submission is this evidence is of a different quality, and this document, what the WhatsApp shows, of a different quality to that, because it doesn't really show as a matter of substance whether there was a contract. It could show aggrieved, you're walking away from a gentleman's contract. What you're looking for in substantive, subsequent contract after the alleged conduct after the alleged contract is something of substance which suggests the presence or absence of a contract.
And because it's a bit different, you get into this subjective objective
You do.
tension. So in your case, we don't look at what Mr. Lee genuinely believed. On your case, we look at what the reasonable fly on the wall would have understood him to believe
Yes,
from what he said.
yes.
So when he says the deal was finalised, we should assume he meant he thought the deal was finalised, and when Mr. Redrazani says, I know, leave it with me, we should assume that Mr. Redrazani was agreeing with that.
Perhaps also thought the same, but as I say, these gentlemen use the word deal before you've got anywhere near in legal terms of
I
contract.
understand that.
So one has to exercise an element of caution in that regard. And also, as I say, my submission, and I'll come on to show you what I think is the only.
Do you say there's nothing in the word stay? Stay committed in what agreed? So A, he's not using the word deal. He's saying stay committed, which one might have thought implies there is already a commitment.
Again, I mean, we are, and I found myself doing this in preparation for this hearing, a lawyer poring over non-lawyers' words in a very informal WhatsApp exchange. But it's not, your question is not without merit, my lord. The point I would make is that's equally consistent with these guys having felt they've got their agreement in principle, they've felt, in my submission, they've achieved preferred bidder status, they've got over that, and immediately it's undermined because someone else has up the offer, and they're annoyed about that. So stay with us is what that means in my submission.
I mean, your case would map very easily onto a sale of land in this country.
Yes.
You know, you put in your bid, it's accepted.
Junior's looking at me because he made this analogy.
Yes, I see. You put in your bid, it's accepted. The bidder says, will you take the property off the market? You say, yes, I'll take the property off the market.
Exactly.
Then along comes a higher bid. You say, who cares about what I said earlier? It's I'm free to gazump you.
Yeah, I agree. My learned junior has been making that analogy all the way through. And he's also just handed me a note, my lord, in response to your question, which is stay committed imports the suggestion that you don't have to stay committed. But again, I would say that what we're looking at is informal, immediate responses that are not really, it's difficult for me to be too particular about them. I don't want to read too much into them. What I'm saying is that they are equally consistent with two people who clearly wanted Coupang to move forward and are annoyed now that someone's coming with another bid in exactly, I would say, the setting your lordship has just given.
Can I just explore your concept of the preferred bidder?
Yes, please.
If there is a commitment to someone as the preferred bidder, what does that mean if actually any other bidder is free to come and gazump?
Well, because at that stage, the parties had made a commercial decision to move forward with Coupang, but at the same time, they hadn't, in my submission, signed on the dotted line. They hadn't made themselves into a formal contracting position. So they were wanting to move forward into that lengthier process, and someone's come in the very next day and gone, here's another $1 million.
But all this is in the context of are DAZN allowed to consider these further offers in the light of what the deal in which we had finalised. So it's all in the concept, not of whether you're merely a preferred bidder, but others are free to come in. It's whether we had a deal which meant others are not free to come in. isn't it? I mean, that's the whole context of this.
Well,
This
I
debate,
kind of
isn't it?
agree. I do agree, my lord, but I'm not entirely convinced that there is much to be gained from an intricate reading of these WhatsApps, because my submission is that these two gentlemen is what I was aiming towards when I wrongly perhaps used the word arm's length, but are like each other and want to work together, and they're annoyed that this has happened. That's clear from these WhatsApps, and they're exchanging their annoyance. And there may be all sorts of things going on. Mr. Radrazani trying to keep his commercial and personal relationship alive with Mr. Lee by saying placatory things. One has to be
Take us
careful.
on neatly to top page 92, where we get the exchange. She's on the 4th of March, where Mr. Sorry, I'm struggling to pronounce the poor gentleman's name, which is my fault, not his. Where he says, I asked Charles to confirm yesterday by email, and Mr. Lee replies, yes, very good choice.
Yeah.
So,
Why was that important?
Well, I say that that's these two gentlemen trying to position Coupang to be in a better position to move ahead. So if you've made a...
surely the point is Mr. Radizani is saying he's got Mr. Marr to sign off on it.
Well, Mr. Marr is not a senior person. It's not Mr. Marr's sign off. We can all see it's the
You're no longer
management.
disputing that Mr. Marr had
Oh
authority.
no, I'm not. I entirely agree with that. But I'm just saying, in fact, what I'm saying is that that's equally consistent with them saying, all good, at least I can show them this exchange of emails. We've got something concrete to show them. What those emails mean is a matter for your lordship. But
To show them for what purpose?
To
To
try
show them to the other bidders to say, there's nothing here that stops you bidding.
No, not to the other bidders, my lord. I
Well,
quite
to
agree. But internally, to say you've got to stick with our agreement in principle. You've already selected Coupang. Whether or not that's a legally immediately binding one, a sort of gentleman's, the gentleman's agreement point to say, well, we've emailed them. We're moving. That was the decision you made. We're not going to just change our minds because Coupang.
Yeah, sorry, I'm sort of to come back to the question I asked because I'm still not sure I quite understand your answer to it. So what I was doing was testing your hypothesis that the explanation for the tenor of these WhatsApp messages is these are two friends, and they want to be doing business with each other. And I understand the force of that solution, but the question then is this: why, if that's right, does Mr. Radizani say that it's important to ask Charles to confirm the estate by email? Mr. Lee replies,
It may or may not be important ultimately, but they think it's important. It's because they think that that is a step. Now the question is, what step is it? It doesn't answer that question. Was it a legally binding step, or was it in fact the commercial decision that there was an agreement in principle and that they were going to move forward with Coupang, and that's been shown in the emails? Now that's the as much, I think, insight as can be gleaned from
In order to persuade senior management that they shouldn't go back on what is no more than an agreement in principle, but not binding.
Or you could say, look, or you could go and say, look, this is no way to do business in the market. Once you've decided you're going to go down a route, yes, okay, we don't have the contract. But once you've decided to go down that route, we don't want to get a reputation for chopping and changing and being unreliable. Whatever Mr. Radrazani wants to say internally, that's an example of the classic commercial internal pressure saying, look, we've already emailed them. This isn't, we shouldn't be doing this. Now, whether legally that matters is a different question. So that really is the nutshell of my submission. And you can look at all of these because they continue. But they continue, and I don't want to be accused of skipping over them. She says skipping over them. But I will carry on because I don't want to give a partial, I'm very keen not to give a partial drop through the, so perhaps I'm conscious
do
of
we
the
need
time.
to go all the way through to page, whatever it is, 96?
We do not, my lord.
Glad to hear.
We do not. But the last submission I have to make, and in a way I'll make it now to bookend it, which is on page 95. Sorry, perhaps I'll just take it in order. I'm sorry, I don't want to delay your lordships or make Mr. Morrison go back any more than he has to on these points. But look what happens. on the 4th. There's that little flurry between them, and then nothing happens for about a week. Do you see that? On 92, just above punch hole. The next thing, and the next conversation we need to go to, first of all, is 108, my lord. This is Mr. Marr and Mr. Kim, trying to keep on the same date. On the 4th of March, Mr. Kim says, "Hey Charles, John will call you to ask you some questions regarding Apple's new offer." But we don't get any more insight into that. Then I think, sorry, I'm just trying to...
Sorry, since we're on 108, can I
Yes.
ask you this question? On the 4th of March, 3:57, we get the 3 messages from Mr. Marr: done, sent, and sealed.
Yes.
What in your position is meant by and sealed?
I don't know, my lord. I think that's obviously about the basketball, I would say,
Yeah.
based on the previous one. Did I receive an email from you regarding the
sorry,
cycle
it's
3?
okay,
It's
yeah.
okay, but I think that means that's the end of that. They've done it all on that. So it's done, it's been signed, it's been sealed, and it's been sent. As I understand it. But I don't know that. I agree. If any of those words had been used in my case, I wouldn't be standing here.
Well, but if it's just an email, which is all it appears to be, I mean, I take your point. It's basketball, it's not our competition. But
Potentially, if there'd been, by way of analogy, if we had those emails and we could perhaps engage in a comparative exercise, but we don't, and I say nothing can be gleaned in addition from that. And then I would actually, the only thing I would say, you can
but then
take
look at what Mr. Kim says. 359, looking at working on the contract for this one too.
yeah, I would actually rely on that, my lord, as saying, well, what are we doing that? It's not done, sent, sealed. I mean, again,
So again, it all comes back to the same point, which is on your case, this is all subject to contract.
it does, my lord, yes. And then if you look on page 109, because nothing's happening, if one remembers, with Mr. Lee and Mr. DAZN until the 12th. But here on the 6th, between Mr. Kim and Mr. Marr, "Hey Charles, I heard that Andrea and John is aligned that nothing will change despite Neville's new offer." Again, it is somewhat barren, but I would say that the idea that something could change imports potentially, objectively, the idea that these guys knew it could. Looks like we're in a good spot, thanks for your support. Yes, this is accurate. I do not think we're going to move our existing position. Same submission. I'm not sure how much help ultimately these provide. Now, further down, here is what I say is a different type of email, because, sorry, WhatsApp background message, because it's much more like, in my submission, the tank and the DERV. Because it's not saying, wait, there's not a bidder coming in. What you've got is Mr. Kim texting Mr. Marr, just below the hole punch, on the 3:48. "Hey, just being inspired by Nava, we do want to start promoting the CWC on our platform. I suppose we should announce once the contract is sealed, but I think we should start exploring options with Ulsan HD, if that's okay." And he says, "assuming that the contract may take a while longer." Pausing there for a little sidebar, my learned friend seems to suggest that time is of the essence, and cites Proton, obviously a very different case about spot trades, but there's no indication that the contract is being hurried or there's some desperate urgency to do anything in my submission. I do accept the more constrained 6 months as opposed to 18 months that we went through with Mr. Corp earlier. But beyond that, there's no particular time urgency, and certainly not of the ilk of Proton. It's got to be now. So that's just as a sidebar. Assuming the contract may take a while, Mr. Marr says, "I think the earlier you guys start promoting CWC, the better. This is my personal view." Mr. Kim says, "Yes, yeah, we just want to get on top of this ASAP because marketing needs some planning ahead. Of course, we won't publicise anything without letting you know first." And our point, submission below is here is a short one. If you were the rights holder already on a binding contract, you wouldn't be checking with your counterparty about whether you can do this. at most you'd be saying, we're going to be starting marketing, this is what we're going to do. Or we're just letting you know we need to start marketing now. So when one's trying to look for some,
Well, even if it's a clear exclusivity deal, one might have thought being aligned on matters like that will because of some sensitivity.
well, I mean, I'll come on to my questions when or maybe I won't, when the judge actually, what he actually says about that. Because what the judge actually says about that doesn't make much sense. Because he says, oh, well, they might be talking about the need to do it before the contract is sealed. Well, if marketing was so important to them, and that's what he says, it would have made much more sense to have that in the initial deal and then roll it out from here. But that's not what happens, because there is no initial deal, and they ask 3 times. I think I can shortcut it. So I need to go and look at it because they're all the same. They ask 3 times, can we do this before the contract? And they don't rely on the existence of a contract saying, here's our rights. They refer to the absence of a contract as being the problem. And that is doing one's best. Most likely, the probabilities are that that's because there is no contract between these parties. So they're trying to do something back to front. We've got a shorter time frame, the contract's going to take ages. Please let us. I know we haven't agreed, but please can we do it? They're not talking as a rights holder there. And that, in my submission, is the most important thing that can be gleaned from these WhatsApps, because it is behaving as if there's an absence of a contract, not the presence of one.
Well, I do hesitate to interrupt, and of course Ms. John has had a lot of questions, and I take full account of that. We had agreed that she would finish by 12:30 or sooner, so that we had equal time for reply. Your Lordships may well wish to give her a little bit more time, maybe a few questions to ask me, but I thought I should flag that point.
Yes, I see. Well, Ms. John, let's keep going at any rate to 1 o'clock. If you can finish by 1, that would be helpful.
Can I just examine? I was trying to be fair.
No, I followed that, and of course, by going through all these
and
matters, Mr. Morrison won't have to do so much himself.
He may. I wanted to avoid him. It's not very helpful to have a partial one where I ignore something that I perhaps think is less helpful, but it does take a bit of time. So I'm conscious. Let me, as I say, I won't take you. There are 3 examples of this, and they're all in our skeleton, I hope.
Yes.
But just so that you've got them, there's this one. There's repeated between Mr. Lee and Mr. Marr. That is on page 105. 4 days later, he's chasing the contract. He says, if we are not able to sign the contracts in time, we think it's okay to start promotions in advance. And Charles, and by the way, Charles Marr only ever gives his personal answer. It doesn't give DAZN's answer. Here he says his personal recommendation, but over the page he says you've got to ask Andrea, you've got to ask Mr. Radrasani, contract is still being drafted, etc. That all indicates that acting as if there wasn't a contract. And in fact, we can go back and we can see that he does ask Mr. Radrasani, just above the hole punch, on the 12th of March, all well, and this is before the balloon goes up, as it were, I can put it that way. We have yet to receive the contract for CWC and wondering when we can receive it. We plan to start promotion. And all of this is consistent with there being no contract in my submission. Then we get you need to be aware that NAVRA is putting pressure on DAZN CEO. They increase that at 4.5 million. That's 6 lines up from the bottom. Top of the page. Honestly, this is very concerning. It's going to be a big problem now. If the deal goes wrong, I want to protect you. I thought the deal was done and confirmed last week. Why do you want to distribute on NAVRA while you're working with us? Is DAZN totally considering the offer? I can't believe it. But then you can see Mr. Lee is under pressure internally, because in the middle, just below the middle page, at 11:38, he says, I'm getting a lot of text messages from company. This is crazy. Mr. Radrasani says, just to be fair, management approved your deal twice. I make all the same submissions I made earlier and don't repeat. And then Mr. Lee says, so it's just about money. You can see that 6 lines up from the bottom. And they're talking about the need to speak to Shay, who's the CEO. And then I rely on this 94:13, not my style and way I do business with my companies. So I'm sorry, I don't like what's happened. Mr. Lee says, it's not your fault, like you said, we have time to fix this. Well, that's not spoken like someone who thinks he's got binding contractual rights in my submission, or you could read it either way. I know this is not your style, otherwise he would have stated it's his management decision. over the page, I ought to, in fairness, point out at 95 at the top, it says, Mr. Lee says, still on the 13th of March, can you try to convince him one more time? If he's not convinced, we need to take legal actions. I know, trying to help you. Anyway, this is the bit that I rely on, the final bit. Anyway, there is no agreement ready with NAVA, so there is room. Okay, thank you. Please try to get me on call with him. I don't think he fully understands the risks involved.
Sorry, where are you now?
Just by the second hole punch, my lord, at 7:02 a.m.
Yes, that's it. Yeah.
It starts from
Yeah.
7:01. Anyway, there's no agreement ready with NAVA.
Yeah.
So there is room. Okay, thank you. Please try to get me on a call with him. I don't think he fully understands the risks involved. Do you think if we up our money significantly, Shay will work with us? So contemplating making a higher offer, and I say that's consistent with what's been going on across the board. Everyone's making higher offers. There is no binding contractual deal here. In fairness, that obviously Mr. Morrison wants to take you to something else, but that's all I had to say.
Sorry, can I just take you to one more then?
Please.
Which is on the 13th, on page 106.
Yes, my lord. Yes, I'm there.
And at the bottom of the page, talking about Shay should be minding his own business.
Yep.
And John Lee says, sorry, the Japan CEO was probably trying to look good to Shay. And Charles Marr says, yep, it was a closed case. What do you say that means?
I mean, again, I would caution against reading this with a too great a lens. I think Mr. Marr is also, with Mr. Lee, being sympathetic. Again, he thought the deal would they move forward with the agreement in principle. We thought we decided, but three short submissions about what I say overall with WhatsApps do and don't help with. The first is, the position remains that these communications where they matter are consistent with the emails setting out the agreement to agree in my submission, subject to contract. Otherwise, they set out the very basic parameters of the deal. They're not a culmination of extensive or detailed negotiations, but a basic outline of high-level terms, and the WhatsApps go no further than that. Secondly, I rely on the substantive emails in relation to Coupang not behaving like an immediate rights holder in asking permission, even if there was a co-exclusivity point. The point here is that they wouldn't have had to ask permission, they would have had to cooperate with us, but they'd be saying, this is what we're planning to do, etc. If they had the rights and needed to market on their own platforms, they would have just started doing it and telling us what they were doing, not repeatedly ask us that. And that's the strongest objective evidence. Thirdly, Mr. Lee's and Mr. Radrazani's annoyance when DAZN go with the higher offer in the end take matters no further, as they're consistent with my submission as the gentleman's agreement, and Mr. Radrazani being annoyed and embarrassed that DAZN is changing its mind in that regard. In terms of the subject of contract, it is probably likely that in my earlier exchanges I've made my submissions. So I'll put them very shortly, which is...
I mean, I do suspect you've really covered this ground, actually.
I do. That's why I'm just looking at my notes again.
Yes.
I'm trying to see if I wouldn't want to miss something out.
No.
I won't. We say that the subject of contract understanding is not just external content, it's written into the fabric of both the offer and the acceptance, and there are immediate qualifications on both of those, not just one of them, for example, and we're not relying on the external to the intrinsic document said to be the contract. So they're not ancillary, they're at the heart of what are said to be the only brief contracting emails, and it would be eccentric to ignore their position, and especially in the face, as we say, where the judge went wrong, was to say, well, you could have said subject to contract, but again, Mr. Marr and Mr. Kim in this instance were not lawyers. The judge referred to the heads of terms. I showed you the heads of terms. They say in capital letters on the top, subject to contract, etc. That's not what this document was. So to criticise Mr. Marr and Mr. Lee for not doing that, I maintain my submission made below that it's quite.
You showed us Mr. Palk's evidence about those heads of terms. I don't think there's any evidence that Mr. Lee or Kim or anyone else at Coupang had been involved in those heads of terms. And Mr. Lee's evidence, I think, was that his personal experience was that he had been involved in some cases in sub-licensing in which there was no more than an email exchange, and the parties started performing on that basis.
Absolutely correct.
So if we're looking at what goes across the line,
I totally agree. I'm going to make a slightly narrower submission, which is that the judge said, well, you could have used the word subject to contract, you, DAZN, and you did use them on the heads of terms. So if you wanted to use them, you would have used them in the email. And I said that's an error, because those were all drafted by lawyers. Mr. Marr and Mr. Kim are not lawyers, and therefore it doesn't have the same, the judge's finding doesn't have the same weight in that regard. So I entirely accept what you're saying. They didn't see those. I don't rely on them for any crossing the line purpose. I entirely accept Mr. Lee's evidence is different. So as I say, we maintain our submission that here you've got two non-lawyers with very short emails trying to say in the same breath as saying here's our offer, here's our acceptance, we need a contract. That to say that you should brand it as subject to contract is contrary to authority, which suggests you don't need to use those talismanic words. And in my submission, it is actually quite hard to think of how else they could have done it as non-lawyers in the very fabric of the offer and the acceptance. That is a very strong, in my submission, indication that these parties did not tend to be immediately bound, but wanted the contract.
That said, people very generally know about the phrase subject to contract, and all they had to do was stick on subject to contract.
I do agree, but if that's their strongest point, it doesn't answer the question, my lord. I always, it's a bit like you could have drafted the contract more clearly by saying, I entirely accept that. It's a point that's often made. It's not always a winning point in my submission, but not by itself. My lord, what I'm going to do, because I have got lots of submissions about where the judge went wrong, and conscious of our earlier debate, because I took issue with, I'm just going to highlight for you, reason one, the judge gave at paragraph 22.
So we should just turn up the judgment, should we?
Yes, please, it's in the core bundle, tab 10, page 107. The judge says the WhatsApp exchanges prior to and after the exchange of emails make clear that what was intended was that once agreement was reached and the points being negotiated, there would be a binding agreement. Well, in my submission, he doesn't suggest where we might find that assistance in the WhatsApps. It doesn't identify the WhatsApps which make that clear, and in my submission they don't. Doesn't do it by cross-reference or otherwise. So the judge fell into error by construing, but without identifying the actual evidence he relied on in that regard, let alone setting out an analysis of why he said they did that. For that reason one, I've taken you through the WhatsApps to quite an extent, so my submissions about where but there's nothing in there are contrary to what the judge has found here. I won't repeat those. Reason two is at paragraph 23, after the post-email exchange conduct. It was submitted by, I've already made my submissions about that, I'm just checking off where I say the judge went wrong. The judge wrongly relied mainly on Mr. Marr's response, but failed to address the fact that the primary consideration of the parties, as demonstrated objectively by those exchanges, was the absence of a contract. He conflated co-exclusive with a cooperative deal. It didn't behave like rights holders, and he ignored, the judge placed heavy reliance on Mr. Marr's isolated comment, I think the sooner you guys start promoting the better, whilst ignoring the fact that he was saying that was his personal opinion and they had to go off and ask Andrea anyway. So in a later exchange. So properly understood, those don't support the judge's analysis. And of course, there's Mr. Kim's closing remark in a separate WhatsApp exchange where he says, of course, we won't publicise anything without letting you know first. And that's all in the absence of a contract. Okay. So, I'm going to summarise this for you very briefly and then I'm confident I can finish. The injunction's not very long, and I'll take it quickly. But I would like to summarise, before looking at injunctions, drawing the threads together, remembering Smith, that what your lordships are looking for here are words or conduct which demonstrate an unequivocal intention to be bound, and what is not good enough are words or conduct which are equally consistent with the absence of such an intention. The burden is on the respondents, as the party alleging there is a binding contract, to demonstrate that the parties' exchanges evince unequivocally an intention to be bound, and we say they fall considerably short of doing so, and these are the factors we rely on. One, the 27th, and they are cumulative. We don't necessarily rely on one factor above another. One, the 27th of February email is an expression of intention. It's not an offer. It's an intention which sets out basic headline points of a potential commercial deal. These have not been extensively negotiated, as my learned friend would have it, or detailed. It's clear from the background that was available to the court that both in the WhatsApps and the judge had available to him the heads of terms to compare what extensive might look like. It's clear that no such extensive negotiations have taken place. The email of the 27th of February, number 3, refers to moving on to the contractual phase. That's relied on as the offer. That's equivocal. It doesn't show it's objectively ready to be legally bound, or it's at least consistent with the absence of such an intention. Fourth, if it's not an offer, my point that the respondents can't magically render it an offer. Fifth, the 3rd of March email is a qualified assent again consistent with the 27th of February email, by reference to start contract drafting for your review. Not that they're contracting, but they will start drafting for your review. In other words, evincing intention not to be immediately bound is a fair reading of that email. They may or may not like what's in that contract. Or again, it's at least consistent with the absence of that. 6, start contract drafting, i.e. not drafting now. 7th, both parties in the same communication refer to moving into the contractual phase, start contract drafting, and we maintain our point that although the talismanic words are absent, it's hard to see a clearer case that these parties are making a deal subject to contract. In terms of the injunction, this engages the question about exclusivity. And it engages, if you've got the order in front of you, the judge's order.
Just find that.
Yes. It's tab 8.
Yeah.
The core bundle. The relevant order starts at 88. In my estimation, although you need to have 1 in mind, because 1 is the declaration. So if we start on 87, apologies. The declaration in 1F was that the exclusivity arrangements for the claimant and the defendant have co-exclusivity. Paragraph 3 of the order is the prohibitory injunction, where the defendant was prohibited from taking any step in breach of the exclusivity obligations in the contract, including by 1, disposing of the Club World Cup 2025 live and or video on demand broadcast rights for South Korea, including by sub-license to any party other than the claimant, and or 2, providing the Club World Cup 2025 live and or video on demand broadcast feed for South Korea to any party other than the claimant or any platforms or services, including any DAZN social media platforms owned by the defendants or its affiliates. So that's the 2 relevant parts of the order which I'll be submitting about. The 2 questions are, should an injunction have been granted at all? And if an injunction should have been granted, on what terms should those have been? In its appeal skeleton at paragraph 99, so page 82 of the core bundle, Coupang accepts that a declaration will suffice where a party shows a willingness to comply with its terms. The key question is, what were the terms of the declaration, and did the appellant show a willingness to comply with them? And that's all that's required to dispose of this ground of the appeal. The appellant, in my submission, expressed clearly at first instance that it was willing, even anxious, to comply with the terms of the declaratory relief, and therefore we say the injunction was unwarranted. There are many references to the transcript of the consequentials hearing where me, for I appear below, I sought to have the contractual terms set out in clear terms precisely because the appellant wanted to assure that it was going to comply with what the court found. The problem came was that nobody knew what exclusivity meant in my submission. It's a problem then, and it's a problem now. And the judge took his own view about what these parties meant by exclusivity and imposed it.
Sorry, can I be clear on this? Are you submitting, if your clients put this out on YouTube, that's consistent with exclusivity?
Co-exclusivity, yes, because what DAZN has a branded YouTube channel, so you can go onto YouTube, click on the DAZN channel, and that's how it broadcasts, for example. And they had that debate, if your lordship remembers, Mr. Mabrazani and Mr. Lee earlier on. We don't like the fact that DAZN makes it available freely. And we said tough.
I mean, this is why, in a sense, this argument doesn't really seem to be about whether an injunction is warranted. It's about what the obligation is.
I entirely agree with you. And the problem is when you've got an unclear, unformulated obligation to then impose on that basis a restraint on the party is not based in any sure-footed contractual meaning.
But I mean, there was very good reason to think that you intended to do something that the judge actually thought would be in breach of the agreement.
I do agree with that.
So the question is, was he right to think it would be in breach of the agreement?
Well, the problem is that nobody pleaded or proved or evidenced to the judge what exclusivity meant. And what part of my submissions was the embryonic form of high-level terms between the parties.
Sorry, your ground of appeal 4 is that there was no threat. What the exchange you have with my lord just demonstrates is that's not the issue.
Well,
the issue is not whether there was a threat or not. The issue was it a breach, which is not the ground of appeal.
You are right, and I think that bound up in whether it was a threat is the question of whether it was a breach, and I agree that the ground of appeal is not elegantly or accurately drafted in that regard. But that's the ill that the ground of appeal is getting at, and the request that we're making this court to fix, which is that was there a proper basis for making that injunction, which fixed that meaning of what exclusivity meant
See
for
what
these
the ground of
parties.
appeal actually is, shall we?
Yes.
So it's page 16 in the Bible. In determining whether injunctive relief was necessary, the judge relied upon alleged submissions which were simply not known. The record, the judge maintains dismission. Now, on the face of it, that is an allegation of procedural irregularity. It's not even a ground that there was no threat, although you might stretch it to that. But you certainly can't stretch it to there never was any breach in the first place.
Yes, and I do understand your lordship's point. What happened below was that the judge made the order in the terms sought in the declaratory part of the order that I've just taken to you, which included this term co-exclusivity. And then it wasn't until we got, and at a later stage, by the way, hearing number 3, to discuss what the terms of the injunction should be, attempting to agree it in the first instance, we didn't get there, that the issue then came into focus. And I agree that this probably isn't the best way to have drafted it in terms of the ground.
Even if one looks at your supplemental skeleton,
Yes.
which is dated the 27th of May, by which time you did have and the way it's put on page 41 is no evidential basis.
That means that there wasn't any evidential basis. I think what that's trying to get at, sorry, my lord, was that there's no evidential basis for imposing that contractual meaning on these parties.
It's really ground 5 that we're on.
I think so, my lord, yes.
You said we're entitled to do this.
Yeah.
They said no,
No,
you're
you're
not.
not.
The judge said, well, there's no good me leaving that to be dealt with sometime in the future. I need to decide whether you are or not. If you're not, he thought it was the appropriate subject matter for an injunction. That's your ground 4, but speaking for myself, I don't see much weight in that because he was entitled to assume that you wanted to do what you
What I
said
said
you
I
were
wanted
entitled to do.
Yes, I agree with that.
The real ground is ground 5, is why the judge was wrong to treat the non-exclusivity agreement as precluding you from doing that which is in the second part of paragraph 3, isn't it?
And the short point is that in doing so, he did, without pleading evidence or real submissions on the subject, find or even request from the claimants, determined what these parties meant when they said the single word co-exclusivity in the bullet points on that 27th of February email. And what the evidence he had before him was, for example, and I appreciate it's not a line-crossing piece of evidence, but was the heads of terms, which show that in 3 other deals, DAZN has, with different parties, slightly different agreements as to how they will exploit their own legitimate rights, and that includes, for example, the YouTube
But
channels.
can I, sorry, stop. Can I just focus on what you say is wrong with paragraph 3.2 of the order?
Yes. Where are you looking now?
Because I'm on page 88 of the bundle.
Yes.
Because I think if I've understood correctly, your ground 5 doesn't affect Roman 1, disposing of the
No,
rights.
it doesn't, my lord.
It's whether you can provide the broadcast to anyone apart from Coupang on a platform or social media platform which isn't one that you or your affiliates own. Have I understood that?
You're right. And
you say that you should be able to broadcast it, providing it and or broadcast it to a platform that you and your affiliates don't own.
that's right, my lord. And so one is dealing with the rights.
How would that be? The exclusivity being limited to you and Coupang.
Sorry, before you answer that question, can you factor in the way the ground is formulated at page 16?
Yes.
Because I think what we've got you so far is that ground 4 is not the real issue, ground 5. And the way it's expressed in ground 16, trespasses impermissibly on DAZN's distribution rights, which are not identical to its broadcast rights.
Yes.
Now, how does that fit with your objection to paragraph 3, little Roman 2?
Because 2 is dealing with how we exploit how we broadcast.
It's providing rather than broadcast. And the second part is broadcast.
Providing 2
That's
broadcasts.
broadcasting rights. That's not the first bit is providing the 2.
Disposing of the rights by sublicense. So we're saying, yeah, we can't sublicense. 1 is saying we can't sublicense it to anyone else. Okay. 2 is saying we can't provide the actual feed, something the declaration says nothing about, and the parties have not argued in front of the judge, live to any other party other than the claimant or any platform for services, including.
Right, can we just then look at this? It says providing the feed to any party. So that would encompass a broadcaster, would it not? The Korean TV station, let's take a random Korean TV station. That is another party. So you, on your case, you can provide your feed to a Korean TV station.
But I think we're looking at not at the one that I would like to have. At 88, this is the one order the judge made. And I had a different version of what, if you needed. I'm saying you shouldn't have 2 at all. That's the first point. But if you have 2, I had a different suggestion for what you would have.
So your different suggestion, should 2 stand, would be
Yes. Perhaps the best thing to do is to find that for you after lunch.
yes.
And then I won't take up any more time, but just provide you with what that is. But the nutshell of the point is that the judge went. My submission is that he imposed what his meaning of exclusivity was on parties who hadn't negotiated it yet. There's nothing in the background that explains. All you've got is those WhatsApps where they say we don't like DAZN providing it for free. That's the parties knew that was happening.
Right.
And Mr. Rabzai said tough.
If he was right that there was a binding agreement, then he had to give effect to that by reference to what was meant by co-exclusivity. It's the complaint that he made his own mind up about what that meant seems to me something which is not legitimate.
My complaint is that what he had available to him, if he chose to deploy it as a more proportionate measure, was to do what DAZN has done with other parties, because that's what is negotiated. Even if he was right, what needs to be negotiated out in the heads of term agreement, rather than stop us from doing something that the evidence is that we ordinarily do. So there should have been more caution in the Roman numeral 2 than the judge displayed, prior to the parties having negotiated out the full terms of what those rights were.
Forgive me, it's my fault. I'm not. What is it that you ordinarily do, which you say you should be entitled to do, which is prevented by Roman 2?
Well, I'll give you an example. I took your lordship to the heads of terms in the supplemental bundles, and you'll find those in the supplemental bundle at tab 5, page 48. And the way this works at 48, in the introduction, DAZN has agreed to acquire from FIFA the broadcast right to the event, as defined below. The licensee acknowledges the terms, etc. The licensee wishes to enter into an agreement to acquire the right to exploit certain rights, etc. So then you've got onto rights. You've got at 13 the consideration for that is set out at 13, and that involves a whole load of different types of rights, for example, that relate to not just the video on demand, but clips rights and ancillary rights and all sorts of things that may go out on or may not on different platforms. And then you get 16, exclusivity on page 51. Other than as detailed in these heads of terms, the media rights license related to the license matches are granted on an exclusive basis in the territory via the permitted territory means. Now, the co-exclusivity comes in here. Notwithstanding the foregoing, and for the avoidance of doubt, DAZN shall have the right to exploit every license match on DAZN's over-the-top service, known as DAZN, and on any other channels, platform services owned and or operated, and it's the and or operated that the judge didn't like, by DAZN or its affiliates, including through its existing distribution and streaming partners. And then
So it's just the question of whether it should allow you to do it not only for those owned by you or your affiliates, but also operated by you or your affiliates. I mean, is that the narrow area of dispute?
Yes, it was, my lord.
That's what we're on.
Including DAZN social media platforms, which includes the DAZN branded YouTube channel, as I made very clear below. So here you've got parties who have agreed what that means for whatever this territory is. And it doesn't mean what the judge imposed.
What is an example of something that is operated by you but not owned by you?
Well, that is the YouTube example I've just given. We don't own YouTube, but we have a DAZN branded channel on which we put things out, whether they're video on demand, clips, promotional things.
It's my fault for not understanding YouTube well.
I know what you mean.
I'm worried that I
When
don't
you
understand
say
it well enough to
a
answer.
YouTube branded channel on which
Yeah.
you do it,
So imagine
that's
watching.
by agreement between you and YouTube.
Yeah. So
You have an
imagine.
agreement by which YouTube will agree to put out material which you want put out on the YouTube platform,
Well, no,
which comes
no,
under a
it's-
brand.
It's
or not.
user-generated content. Doesn't require any agreement with YouTube. You accept in the sense you have to comply with their standard terms and conditions, but it's just uploaded.
Well, we operate an actual channel into YouTube. So if you opened up YouTube and look for DAZN, we have a channel that we run through YouTube. So, and then what you'll see is the DAZN, it's the little square which says DAZN in the corner, and that's the DAZN branded content that's put out through YouTube.
So the YouTube isn't a social platform operated by you. It's just
It is utilised, operated by us.
it's used by you.
Exactly. But it's not owned by us, obviously.
Owned by
It's
you,
not
but it's not
operated
operated by you.
It's
It's
probably
used by you.
It's not operated by you, is it?
But I'm told the channel is operated by us, but the platform is not.
What do you mean the channel is? Of course, you post content on it in the same way as I could post content.
Of the same, we're being live streamed now, for example, probably. on
I
YouTube.
wouldn't say that involves me operating YouTube.
No,
And the fact that I always brand my posts with prominently with my name wouldn't make any difference.
HMCTS. No,
I'm sorry to spend time on this, but I'm trying
No,
to work out really what
I'm
the
slightly
dispute is on this. And if you added the word operated, I'm
Then
not
you've got to
sure.
look at
I'm
the
not sure
class.
why that would allow you
A
to
part in brackets.
to broadcast it.
You've got to look at the brackets, maybe that's where I was just getting to, including through its existing distribution and streaming partners, including DAZN social media platforms. We say that encompasses our rights to broadcast on our YouTube channel.
Is it only the YouTube channel that we're dealing with?
I don't think it's only the YouTube channel, but I think it's Instagram, TikTok. Please don't ask me any questions about TikTok. Certainly not
Then
for
you're
my-
getting into clips rights.
I agree with you. On TikTok, we're definitely getting into clips rights, but that's also unclear on the current supposed contract. So we're not even allowed to put out clips on TikTok if this injunction stands. And my point is, it goes too far. Now,
Yes, but were clips rights actually debated before the judge?
okay, I don't want to answer that too quickly, but I think
My
we
impression is
mentioned.
not.
I'm not sure it was in terms of my lord, and that's the fairest answer I can give at the moment.
Thank you.
Well, we're-
I'm not sure where I think I've got to come. I've got some homework. I think, which is to sort of say, I keep asking. Perhaps you'll retract it to provide an alternative if you were in the numeral twos. Have I understood that correctly?
that would be
Well-
helpful.
You're not encouraging me, but if I did it, you'd.
Yes. Given the time constraints, I suspect we ought to start again at 2, even though we're a bit after 1.
I'm grateful to both the court staff and the worship for that invitation.
So 2 o'clock.
All rise if able.